Confessions of a Psychotic, Circuit Court Judge, via fraudulent judgments and payment scams.
And of course for that, I only have the pleadings filed and the descriptions delineated in the bills themselves. I do find that hourly rates charged to be fair. I find the time allotted for the tasks performed reasonable.
Is it also fair and reasonable? You play Dr. Killeen's attorney on November the 26th, 2012, and yet again, on this very same day, September the 18th, 2013. Let's listen.
By going with this clean hands doctrine, and believe me, one of the things that we want to do, hopefully, is to cross-examine Dr. Killeen on these, on her testimonies, since that never happened. Sure, but
you won't pay her. She doesn't work for free. She's apparently not in the Bird School of Ethics. I don't know what to tell you.
Dr. Killeen estimated on, and you just touched on this, in her contract that roughly should cost between $10,000 to $13,000. Mr. Stengel's paid twice that. I mean, a considerable sum of money.
Senator, what, 400?
It's alleged.
You can't fuel it and then not pay for it.
That's alleged. I haven't seen any documentation of it. Mr. Stengel will tell you that he said.
Defense number 36, is it? Joe, go get that binder off my couch, please. Not the one that has there's one that has subpoenas and there's one that has emails.
Okay, but Mr. Stengel's contention is that he only sent 84 emails. Maybe there's some that are related. I'm not sure. I haven't seen it.
Although we will focus on one statement by Judith ENSOR, this deserves to be dissected just a bit.
Well, one of the things that we want to do, hopefully, is to cross-examine Dr. Killeen on these, on her testimony.
Not a chance in hell.
You won't pay her. She doesn't work for free.
10-213. Evidence. West's Annotated Code of Maryland State Government. Scope of evidence. F. On a genuine issue in a contested case, each party is entitled to 1. Call witnesses. 3. Cross-examine any witness that another party or the agency calls.
You won't pay her. She doesn't work for free.
That's not exactly true. But this is the one we will come back to.
She's apparently not in the Bird School of Ethics. She's apparently not in the Bird School of Ethics.
There is only one way to respond to that.
Mr. Stengel is the kind of person that I would have to be very careful with my words. I don't know what to tell you. Mr. Stengel is the kind of person that I would have to be very careful with my words.
Besides,
I don't know what to tell you.
Therefore.
10-213. Evidence. West's Annotated Code of Maryland State Government. Scope of evidence. F. On a genuine issue in a contested case, each party is entitled to 1. Call witnesses. 3. Cross-examine any witness that another party or the agency calls.
Therefore.
I don't know what to tell you.
Should be directed towards Dr. Catherine Killeen. That's only if the law applies. Any law whatsoever.
Dr. Killeen estimated on, and you just touched on this, in her contract that roughly should cost between $10,000 to $13,000. Mr. Stengel's paid twice that. I mean, a considerable sum of money.
Senator, what, 400?
It's alleged.
You can't fuel it and then not pay for it.
That's alleged. I haven't seen any documentation of it. Mr. Stengel will tell you that he said.
Defense number 36, is it? Joe, go get that binder off my couch, please.
What happened to Joe?
What happened to Joe?
What happened to Joe?
So what happened to Joe? So then what happened to Joe?
Joe was sent on a mission. You will have to see the over 400 or 84 emails presentation.
Okay, but Mr. Stengel's contention is that he only sent 84 emails.
Again, you will have to see the over 400 or 84 emails presentation. And now, we come back to this one.
You won't pay her. She doesn't work for free.
This includes both fair and reasonable, and
I went through the bills. I went through them line by line. You won't pay her. She doesn't work for free.
having gone through the bills line by line, surely you came to the end. The summary part. Let's take a look at 1. Fair and reasonable. 2. Line by line. 3. She doesn't work for free. 4. And while we are at it, we will throw in Dr. Kimmel. Surely you are wondering, Dr. Kimmel? Follow along. How appropriate is this title? First, you may remember the I think was not stated. Instead she said, he paid Dr. Killeen $26,000. Yet it actually conflicts with her own bill, which notes $26,725. Next, you will notice, like Mr. Berg, Dr. Killeen also received $2,500, well after the date noted in these bills, yet ignored. That was just a sidebar. And not what we will talk about for now. We will focus on the summary. After all, Judith ENSOR is defending Dr. Killeen's position. The very top notes the total bill is $49,820.12. If we look at the lower page, and, as we go, line by line, the first line item notes, April the 7th, 2011, payment from account. Looking across we see, $100. The next line item notes, April the 29th, 2011, payment from account. $4,100. The first line item highlighted notes, May the 16th, 2011, invoice number 2618. $6,632.62. The next line notes, May the 16th, 2011, payment from account. $5,000. The next line notes, June the 3rd, 2011, payment from account. $1,632.62. Here is where it gets interesting. The next line notes, December the 8th, 2011, invoice number 2788. $27,025. The next line notes, December the 8th, 2011, payment from account. $4,000. Now, if you look at the very bottom of the page, and after the noted December the 8th, 2011, payment from account, $4,000. Leaving the client funds in account, at zero. Now we will zoom in on the main section. What this shows is rather simple. On May the 16th, 2011, Dr. Killeen generated an invoice, with the number 2618. The next invoice Dr. Killeen generated, was not until December the 8th, 2011, with the number, 2788. Nearly 7 months later. And with that invoice, it shows an amount of $27,025. Therefore, Dr. Killeen generated 170 invoices during that period, nearly 7 months, just none to Mr. Stengel. Now, if we look below, it shows, on that same day as the $27,025 invoice generated, a line item noting, also on December the 8th, 2011, payment from account, $4,000. Therefore, so not to generate any invoices, $4,000, lay dormant, until December the 8th, 2011. So, what does Dr. Kimmel have to do with this? Again, this too is very interesting. First, we are aware, Dr. Killeen's contractually obligated report, for outside third-party review, was never provided. The same reason, she refuses to be cross-examined. And not, for the reason Judith ENSOR stated. But we will get to that. For now, let's look at the calendar. Dr. Killeen's bill dated May the 19th, 2011, called to Dr. Kimmel. As seen here. And no records requested, or that conversation ever mentioned. In the, do not stop at reality, and go directly to fraud. Curiously, 3 days prior, and in the middle of the month, Dr. Catherine Killeen generates a bill, noted as number 2618. One month. 2 months. 3 months. 4 months. 5 months. 6 months. Nearly 7 months. And a full week after, Dr. Catherine Killeen provides her sworn, under the penalty of perjury, testimony, suborned by Leon W. Berg. Notes are generated invoice number 2788 for the amount $27,025. Yet, 170 invoices generated. Just none to Mr. Stengel. Even holding $4,000. Until December the 8th, 2011, as well. Besides,
I went through the bills. I went through them line by line.
this one, there is no, I think, or I believe. She is sure.
With respect to Dr. Colleen's bill, Mr. Stengels paid $26,000 of her nearly $50,000 bill.
The alienation game is played in all areas by all crime ring members, and is in no way limited to Dr. Killeen's outright refusal to provide her contractually obligated report for outside third-party review. By illegally preventing any expert review, then question how Dr. Catherine Killeen derived at her sworn to, under the penalty of perjury, results. Furthermore, Dr. Killeen's and Leon W. Berg's reasons and excuses why there was no report were simply more lies, crimes, and frauds upon the court. Detailed in another presentation. The alienation game, played with such intent to not generate any invoices for Mr. Stengel for nearly 7 months, until after Dr. Killeen testifies. Why? To also prevent anyone from knowing her actions by way of her line-by-line item billing. And a line item just after that May the 16th, 2011 cutoff, which began what is known as Dr. Catherine Killeen plays hide the fraud bills for nearly 7 months, is none other than Dr. Kimmel. Surprise!
Dr. Alan Kimmel, Ms. Stegel's medical doctor, aware of Ms. Stegel's mental health issues.
Fair and reasonable. Fair and reasonable.
And, for more fairness and reasonableness, Judge Judith ENSOR, on September the 18th, 2013, as you heard, represents Dr. Catherine Killeen, who has not been in court for nearly 2 years, and since her insane number of perjurious pre-planned sworn testimony, Judge Judith ENSOR even stated she demands to hear from Dr. Catherine Killeen, and her opinion only, in regards to any modification of child custody, which Mr. Stengel has been trying to do ever since their child custody scam on May the 1st, 2012, and stated no other expert will do.
Fair and reasonable.
Which brings us back to
Well, one of the things that we want to do, hopefully, is to cross-examine Dr. Colleen on these, on her testimony.
not a chance in hell.
You won't pay her. She doesn't work for free. You won't pay her. She doesn't work for free. She doesn't work for free. She doesn't work for free.
Actually, Dr. Catherine Killeen, by her own actions, insisted on working for free for nearly 7 months. That was in order to provide your crime rings designed fraud for nearly an entire year, and her over 100 knowingly false and perjurious statements under oath and the penalty of perjury. Done so with foreknowledge and malice to cause as much harm as possible to as many as possible. However,
She doesn't work for free. She doesn't work for free.
is very true when referring to Dr. Catherine Killeen being cross-examined or even questioned in regards to her designed fraud for nearly an entire year, and her over 100 knowingly false and perjurious statements under oath and the penalty of perjury. Done so with foreknowledge and malice to cause as much harm as possible to as many as possible. And we must give credit where credit is due, as it is you, Judge Judith ENSOR, who alienated the case via your specially assigned scam. And it was you, Judge Judith ENSOR, who represented Dr. Killeen in being paid her fraudulent bills. And it was you, Judge Judith ENSOR, who insisted Dr. Killeen be the only qualified expert in regards to Mr. Stengel's numerous filings for modification of child custody to even be heard. Furthermore, in regards to
She doesn't work for free. She doesn't work for free.
apparently, that does not apply to the hundreds used and abused, such as Garrison Forest School and other schools they infiltrated, and the teachers they harassed, as they were simply looking for dirt on Mr. Stengel. Yet, it's okay that they work for free, or were the schools reimbursed? And it was you that quashed the subpoenas Mr. Stengel sent out to allow those like the three listed on top, all from Boys Latin School, their headmaster, Christopher Post.
Each party is entitled to 1. Call witnesses.
Line by line.
And it was you that quashed the subpoena for Sherelle Flowers, that school's counselor, who Alex reported being abused too, as Mr. Stengel tried every way possible to protect his children and prevent the abuses.
Each party is entitled to 1. Call witnesses.
Line by line.
And it was you that quashed the subpoena for Jean Campbell, who witnessed Alex's refusal to go with his mother and her deceased son's grant, raped of over $20,000 by Miss Siliski using false financials, which you have personal knowledge about.
Each party is entitled to 1. Call witnesses.
Line by line.
And it was you that quashed the subpoena for Dr. Killeen, who received an email detailing what Jean Campbell witnessed, yet 3 days later, swore Alex never refused to go with his mother, or she be questioned regarding her mountains of perjurious sworn testimony, or, like Mr. Carney, refused she be questioned regarding any of her fraud bills, and further stated,
Fair and reasonable.
Each party is entitled to 1. Call witnesses. 3. Cross-examine any witness that another party or the agency calls.
Line by line.
and it was you that quashed the subpoena for Kelly Weinberg in the psychology field, who testified against Alex Meyer under oath, simply by repeating what Miss Siliski had been telling her.
Each party is entitled to 1. Call witnesses.
Line by line.
And Mr. Stengel can do this.
They think you're psychic. They think you're crazy, okay? They know you're crazy. They've been listening to the stories I've been telling them. They know you're nuts.
Then, one day later, where Alex was kidnapped. Then, Alex and Maya were held prisoners at the Weinbergs. And Mr. Stengel can do this.
December 8th, Alex. So I just finished school and I'm going home with the McCanns, and all of a sudden my mom calls the McCanns and says I have to go to their house. So when we got to the McCanns' house, my mom pretty much intercepted me and took me back to the Weinbergs because that's where she was living right then and there. So after I was fine for like a couple of days, then after 4 days I started to feel prison, and then about 6 more days I started really sad. So then I called Dad, and Dad picked me up like really early in the morning so I could get out without Mom trying to stop me. And it was kind of scary because I knew if Mom caught me it would have been a big disaster. So Mom tried to, I had a basketball game that day, so during the basketball game Mom tried to she tried to take me back, convince me to coming back to the Weinbergs. But I didn't want you to know I'm with Dad. And I'm having a good time. Alright?
And on that day, and Mr. Stengel can do this.
Day December 18th. The day I finally broke out of prison.
And it was you that quashed the subpoena for the R-strikers who were conned to uproot Alex Meyer a mere 11 hours after that phone call to Mr. Stengel's older son, stating his father just told her he wants a divorce.
Each party is entitled to 1. Call witnesses.
Line by line.
And Mr. Stengel can do this.
Your father and I are definitely divorcing. Andrew just told me tonight.
Or Betsy R. Stryker, who testified against Alex Meyer under oath, simply by repeating what Miss Siliski had been telling them.
Each party is entitled to 1. Call witnesses.
Line by line.
And it was you that quashed the subpoena for Catherine Barrison, who was conned by Miss Siliski in yet another staged event to think she found some hidden camera and was being groomed to swear under oath. As you were provided and fully aware, the video clearly shows the driver, Miss Siliski, a full month prior, pointing to that very camera. And Mr. Stengel can do this.
And it leads to the camera.
No, that's bad.
No, because my yelling is from frustration.
No. Yeah, I think, well, I don't know.
Frustration and resentment. Frustration and resentment. and it leads to the camera, and it leads to the camera.
Each party is entitled to 1. Call witnesses.
Line by line.
And Mr. Stengel can do this. Mr. Carney's bill notes.
November 29, 2011, call from witness Catherine Barrison regarding hearing. 0.10 hour, and billed $20.
Line by line.
Which Mr. Stengel should pay.
Line by line.
And Mr. Stengel can do this. From Susie Siliski, Susie@onivators.com. Date: December the 30th, 2011. 2. Many people in contempt of the December 22nd, 2010, court order.
Subject: Court January 5th. I just wanted to let you know that, as of this morning, we are still scheduled to have our second day of the Pendant Light custody hearing on January 5th. However, I do need at least 3 witnesses that day. I have confirmed Catherine Barrison and my mom. Catherine will testify specific to the hidden cameras. So, if someone else is willing to speak on my behalf, without a subpoena, please let me know. We need someone who will talk about my character.
Note 1 further confirms the January 5, 2011 trial date, which the crime ring slimeballed around, with multiple reasons. 2. Contempt of court. Again. 3. More papering, while conning while papering. 4. Preparing to suborn perjury. 5. Have Catherine Barrison commit perjury. 6. Without a subpoena. Why? Because Mr. Stengel would get a copy and prepare to destroy Catherine Barrison with reality, while on the stand. 7. Needs a character witness. 8. I believe Miss Ileski's actions speak loud enough. However, if anyone would like to take the stand and describe their level of delusion, raise your right hand and swear. 8a. Don't worry, Miss Ileski. Many will be doing just that. 9. Mr. Stengel received this in response to some of the subpoenas he sent out. Reality: weeks before this email, they were all colluding and conspiring to postpone that January the 5th, 2012, cross-examining of Dr. Killeen, as can be seen in their own bills. There was no way in hell they were putting Dr. Killeen on any stand. This is all meticulously dissected in a later presentation. And it was you that quashed the subpoena for Alison Meister Friedman, who was conned to commit perjury, and just weeks earlier, ignored a subpoena. And Mr. Stengel can do this.
Yeah, I've been around him before, the Halloween before. His son Alex and my son are very close friends, and they had come. Alex had come trick-or-treating at my house the Halloween before, and Alex was with his mother that night, and Mark came to our house unannounced.
Except Miss Siliski left out one small detail, but rather large in regards to her staging yet another scam. Email from Miss Siliski Stengel, Sunday, October the 31st, 2010, at 3:09 p.m., to Mr. Stengel. Subject: Halloween.
Would you like to meet at 5 p.m. at Meister's to trick or treat?
Note 1. This, the day after Miss Siliski, with the assistance of Betsy and David R. Stryker, in uprooting the children on their father's birthday. 2. In fact, the very email states,
Maya has been asking to come home.
It's clear, Maya, 8 years old, is being held against her will by her mother, and her liberties being restrained. And Mr. Stengel can do this.
Ms. Friedman, are you aware that Ms. Stengel had sent Mr. Stengel an email requesting that he come over that Halloween night? Are you aware of that?
No, I'm not aware of that.
Thank you.
That was a full year later. Yet Mr. Carney was fully aware of that.
Each party is entitled to 1. Call witnesses. 3. Cross-examine any witness that another party or the agency calls.
Line by line.
Alison Meister Friedman conned and played like a fool to commit multiple counts of perjury on November the 23rd, 2011. Mr. Carney even had her come without a subpoena. However, after that, they refused to allow Alison be questioned. You may start to notice the repeated actions. Either commit an insane amount of perjury, then refuse to be questioned. Sound familiar? Sound familiar? Or, the same thing occurs outside the courtroom, by lying to everyone to get people involved, to do their dirty work, then refuse they be questioned, or made aware of the abuse waged upon them, and the abuses they are conned to partake in. The quashing of subpoenas is simply just another tool to keep their victims in the dark. So, when each subpoena is quashed, that's the crime being committed to their victims by Mr. Carney, Miss Siliski, and the fully aware and fully participating Judge Judith ENSOR. Each one is a criminal act. Bradford G.Y. Carney, a boys' Latin school alumni, was aware of much more, as was Judge Judith ENSOR, as Alison Meister Friedman has her own presentation, which itself is an hour long. And it was you that intentionally quashed the subpoena for Alison Meister Friedman. And it was you that quashed the subpoena for Joe DiMello, who was conned by Miss Siliski to commit numerous crimes, as noted in Mr. Karsiski's 148-page package to the state of Maryland, regarding the state's fraudulent criminal charges and falsely incarcerating Mr. Stengel.
Each party is entitled to 1. Call witnesses.
Line by line.
And it was you that quashed the subpoena for Stuart Zolotoro, the photographer, who was conned by Miss Siliski to write an email to Mr. Carney, stating the kitchen cabinet event looked staged. And Mr. Stengel's research against shows allegations equals confessions, and the staging was being done to Mr. Zolotoro and by the driver, Miss Siliski. And the many driving emails by Mr. Carney, long after, even having Mr. Zolotoro go to the police and file a false police report, which the police finally rejected.
Each party is entitled to 1. Call witnesses.
Line by line.
Although Mr. Zolotoro has his own presentation. Quickly. And Mr. Stengel can do this. Mr. Stengel intentionally sends out only a 5-second clip without audio, knowing she will con and lie about it. From Mr. Zolotoro to Mr. Carney. Wednesday, January the 26th, 2011, Mr. Zolotoro writes,
Brad, I have known Susie since 1994. We worked together at the Associated. My wife and I were at her wedding. We were quite disturbed a few weeks ago when we received an email from Mark Stengel. It had a video of Susie and Mark in their kitchen. The video looked staged with the cabinet hitting Mark.
A few weeks ago? So disturbed. Yet, waited until Miss Siliski stalked. Coincidentally ran into the Zolotoros' 3 giant supermarkets from where she was living. And directed/demanded this letter be written. And Mr. Stengel can do this. Almost a year later, Mr. Carney's bill notes,
October 14, 2011, read email from Stuart Zolotoro and draft response thereto. 0.20 hours, $475.
Line by line. He is just papering my death.
And Mr. Stengel can do this. 6 months after that, now April the 12th, 2012, Miss Siliski swears under oath,
which Mr. Stuart Zolotoro, a professional photographer, would testify in court that didn't happen that way.
Next question.
So no, I did not. He was standing there and he got hit.
You just witnessed identity theft, identity fraud, and perjury by Miss Siliski, and suborning perjury by Mr. Carney, for starters. A psychosis trifecta, which continually repeats.
Each party is entitled to 1. Call witnesses.
Line by line.
Therefore, Mr. Stengel can't question Mr. Carney regarding his bills, or Mr. Zolotoro regarding his bills generated by Miss Siliski and Mr. Carney. And ENSOR makes sure that will not happen, yet demands Mr. Stengel is responsible, and should pay those bills. Do we have this correct, Adolf, ENSOR? To make it easier to understand, they bombard people with offensive assaults, then they end the game, which is breaking many United States constitutional laws as well. Everyone has a right to be heard. Everyone, especially those intentionally violated and abused, like those whose names are being used without their knowledge or with their knowledge, but under false pretense. And it was you allowing Mr. Carney to illegally represent the many others in quashing their subpoenas to further alienate your crime ring's victims by removing their rights as well. For them all to hear questions, shown actual evidence, they were all conned and manipulated to the detriment of Alex and Maya, to then speak freely for themselves. And what are Mr. Carney and Miss Siliski claiming? Noted as number 7.
Almost all of the subpoenas issued by the plaintiff were to third parties and entities that possess no information relevant to the issues.
How would Mr. Carney know that? Did Mr. Carney or Miss Silisky ever advise any of them what the real issues were? Besides, allegations equals confessions, as Mr. Carney and Miss Silisky, like the entire crime ring, are well aware. The exact opposite is the case. That is, only if we sprinkle some reality on their frauds. However, in regards to the issue of fraudulently and falsely having Mr. Stengel incarcerated, they appear to have lots of information. Got it? Mr. Carney and Miss Silisky further state,
were issued by plaintiff, in an attempt to annoy, embarrass, and oppress defendant and those persons or entities subpoenaed.
Note 1. Defendant, Miss Silisky, can't be embarrassed, as that would require feelings. 2. Regarding those subpoenaed, and the words, annoy, and oppress, we have a classic, allegations equals confessions. Mr. Carney and Miss Silisky, noted as number 8, further state,
subpoenas issued to the following persons should be quashed, as these individuals or entities have no information relevant to the financial matters pending.
Even if one were to ignore all the realities of that statement, and Mr. Carney's bills in these very regards, we are still left with the fraudulent financial nature of this motion itself, and this special hearing called on November the 26th, 2012, which also added to the very financial nature, unless Mr. Carney was doing all of this for free. And what do you think will happen when the largest legal action ever brought against a state is brought against the state of Maryland, who authorized many of these criminal actions and forwarded the victims' lists with full knowledge, as well as this crime ring, their firms, and all those responsible, as well as the Oversight Commission and their employees who are accepting paychecks to protect the public, including the American Psychological Association and their Maryland branch, who knowingly permitted these abuses to continue, even acting as a shield for crimes against the public. Do you think these people and the hundreds of other victims will join any litigation, or do you believe they will stay the course and ride the delusional trolley to defendant's lane? Where might you think Boys Latin School of Maryland will plant their reputation, and what lessons will they provide to their students and families? And, not to disappoint, what does Judith ENSOR have to disparage Mr. Stengel about in those very regards? Class, we already know, it's allegations equals confessions. So let's get right to it.
There are rambling emails and irrelevant subpoenas. There are rambling emails and irrelevant subpoenas. There are rambling emails and irrelevant subpoenas.
Really? I believe this presentation shows otherwise. Therefore, there are rules the judicial branch are required to follow. One of those rules are as follows.
10-213. Evidence. West's Annotated Code of Maryland State Government. Scope of evidence. F. On a genuine issue in a contested case, each party is entitled to 1. Call witnesses. 2. Offer evidence, including rebuttal evidence. 3. Cross-examine any witness that another party or the agency calls.
Should there ever be any reason whatsoever Mr. Stengel needs to be in court, that court should be made aware Mr. Stengel may call over 100 witnesses. Therefore, with rules governing the restriction of time to properly put on any case, the court should allow several weeks, at a minimum. The list will also include Judge this Judith ENSOR, Judge this Kathleen G. Cox, Scott D. Schellenberger, Jill P. Savage, the entire crime ring, of course, the companies, attorneys, associates, all those listed in their gag frauders, just for starters. Also, if applicable, Mr. Stengel will be requesting a jury trial, which may be difficult, given so many are taxpayers, therefore victims, themselves. Besides,
Rule 2.5. Competence, diligence, and cooperation. A judge shall perform judicial and administrative duties competently, diligently, promptly, and without favoritism or nepotism. 2. A judge should seek the necessary docket time, court staff, expertise, and resources to discharge all adjudicative and administrative responsibilities. 4. In disposing of matters promptly and efficiently, a judge must demonstrate due regard for the rights of parties to be heard, and to have issues resolved, without unnecessary cost or delay. A judge should monitor and supervise cases, in ways that reduce or eliminate dilatory practices, avoidable delays, and unnecessary costs.
Say what? Anyway.
Contains entries for work performed as a result of Mr. Stengel not letting the children communicate with Ms. Stengel when they were in his company. I mean, it shouldn't be an issue. It simply shouldn't be an issue. There shouldn't be that problem, so there shouldn't
Do we need to pull all of Judith ENSOR's knowingly false statements on that September the 18th, 2013, fraud decision day, to justify this crime ring's frauds? Such as, it was Mr. Stengel who would not allow phone access for the children to speak with Miss Siliski, and the reason that consent order was needed. Watch how Miss Siliski manufactures counterfeit orders and fraud bills. Let's look a bit closer. Pay no attention to the 38 emails part, and the various drivers Miss Siliski and Mr. Carney solicited, nor the next entries, also emails. Below, Mr. Carney's bill notes.
December 27, 2010, Susie's email of December 25, 2010, regarding inability to reach Mark by phone. 0.40 hours, for $150.
Note, Miss Siliski sent that email on the 25th. However, if we look at Mr. Stengel's phone records, or, as some may refer to it as, reality, we can clearly see a call to Miss Siliski on December 23rd, 2 calls on the 24th, noted as incoming, where Miss Siliski apparently called, and was called back, which lasted 7 minutes. There is even an incoming call on the 25th, at 2:14 p.m., which was answered. Answering an incoming call, something you will not find even one time, in Miss Siliski's phone records. That call lasting 5 minutes. The very day of her email. Apparently, this began on day 1, and never stopped. And now we learn, Judith ENSOR herself, is one of the main drivers. Because every crime ring needs a captain. And, like the emails, Judith ENSOR sent Joe to find.
I only have the pleadings filed and the descriptions delineated in the bills themselves.
Because Judith ENSOR stated she used the fraud bills, which Miss Siliski, the driver, generated. However, Mr. Stengel has the actual phone records that prove her allegations were not only false, but it was Miss Siliski doing just that. Or, can we assume, like the rest of this crime ring, it's not only all bullshit, and knowingly so, but in fact, the extreme opposite was, and is the case, with every single fraudulent allegation, such as,
he is the driving force behind this litigation. He is the driving force behind this litigation. He is the driving force behind this litigation.
Why would Mr. Stengel subpoena people that would be bad for him? And why would Mr. Carney and Miss Siliski provide this quashing motion to squash those witnesses from testifying if they were bad for Mr. Stengel? Or was Mr. Stengel continually trying to protect his children, therefore needed to expose this list of victims that they are in fact victims of this crime ring, therefore putting on the brakes, if you will? And this crime ring insisted on keeping these people and the hundreds of others alienated, therefore to continue the driving, if you will. And wouldn't Judith ENSOR, allowing the illegal quashing of these subpoenas, and done so knowingly, make Judith ENSOR herself one of the main drivers? Furthermore, Judith ENSOR could have applied the brakes whenever she wanted to. In fact, Judith ENSOR was not only one of the main drivers, but as seen here, refused to allow Mr. Stengel apply the brakes, which makes you the cause and creator of the abuses. And it was you, a full-blown psychopath, who on November the 30th, 2012, after knowingly demanding the abuses continue, at this point, for 2 years, and on this last day of trial, on page number 107, further confirm your evil psychosis by stating,
they learn about them from their parents. When they see that the parents who supposedly loved each other at one point, when they see how their mother treats their father, when they see how their father treats their mother, they don't know that they are in a world that no one should live in. They think that's how it is. They're not going to have healthy relationships. And I don't know if they're going to have healthy relationships even with the therapy they're receiving. It may be too late. But these people may have ruined their children.
Thank you for your confession. One person, Judith ENSOR, allowed to come in did not even show up. After summoning Mr. Neil Swear into the courthouse, testified, he in fact paid Miss Siliski several thousands of dollars in 2010. Is there any other evidence needed, then, this, which is being provided? It's all in fact, the complete opposite to their claims, and to reality. Surely their victims were told, they are helping them out, with crazy, Mr. Stengel. And in line with, the delusional world, Mr. Stengel's research subjects, all live in. Like all their drug claims. We have Mr. Bradford G. Carney, is an alcoholic, and drug abuser. We also have Miss Siliski. And, Mr. Stengel, can do, this. What time is Miss Siliski getting drunk? There just so happens to be a clock behind her. 2:50, in the afternoon.
Well, again, no, we're not going to revisit things, and your attorney and Mr. Carney agreed that Mr. Berg's fees were fair and reasonable and necessary, and that Dr. Colleen's were. That's not something we're going to revisit.
Apparently, that also applies, whether or not the bills were made available. The important part is, Mr. Lazaro and Mr. Carney agreed. And the really important part is, there shall be no questioning of any bills. That's an order. Just so everyone fully understands. Tell us again.
This is one of those tricky things.
Say it again.
This is one of those tricky things.
The Maryland Commission on Judicial Disabilities, Commission, is an independent body with the power to investigate complaints against Maryland judges and, when warranted, conduct hearings concerning such complaints and take certain actions or make recommendations for other actions to the Court of Appeals. Through the exercise of its powers, the Commission plays an important role in promoting public confidence in, and preserving, the integrity and independence of the judiciary. Commission on Judicial Disabilities. Rules for Judicial Conduct and Judicial Disability Proceedings. Article I. General Provisions. H. Misconduct. Cognizable misconduct. 1. Is conduct prejudicial to the effective and expeditious administration of the business of the courts. Misconduct includes, but is not, limited to, c. having improper discussions with parties or counsel for one side in a case, d. treating litigants, attorneys, or others in a demonstrably egregious and hostile manner.
Then there is the child custody scam. On May 1, 2012, please correct this if need be, but there was Mr. Carney, Mr. Berg and Mr. Lazaro in Judge Judith ENSOR's chambers for over an hour. Yet, Mr. Lazaro had not signed into the case yet. It wasn't until after Mr. Lazaro lied to Mr. Stengel, telling him it was temporary, a couple of weeks, did Mr. Stengel agree, and then, is when Mr. Lazaro signed on to the case. All dissected in another presentation. Yet that chambers meeting was.
Rule 2.9. Ex parte communications. A judge shall not initiate, permit, or consider ex parte communications, or consider other communications made to the judge out of the presence of the parties or their lawyers, concerning a pending or impending matter, except as follows.
This is one of those tricky things. This is one of those tricky things. Fair and reasonable.
The queen of ex parte communications. Like Donald Trump, she can't control herself. All the research subjects are the same.
And of course for that, I only have the pleadings filed and the descriptions delineated in the bills themselves. I do find that hourly rates charged to be fair. I find the time allotted for the tasks performed reasonable. Fair and reasonable. I do find that hourly rates charged to be fair. I find the time allotted for the tasks performed reasonable.
Dear Judge Judith ENSOR, having been a lawyer yourself, surely you had accounts of your own, over the many years, that would reflect the same reasonableness, correct? How about just a couple? Do you have just one, where you let a client go without being paid, similar to the one you are ruling, is fair and reasonable? Are you saying, it is necessary, to work without being paid? Surely you have presided over other cases as a judge, which reflect these same scenarios, and ruled the same way? Do you have just one other case? What about just one, where an attorney even requested this, in your courtroom? Furthermore, you state Mr. Stengel's attorney, Robert Wayne Lazaro, agrees to the fair and reasonable mantra. As you are well aware, Mr. Lazaro himself kept getting out of the case 3 times, each time claiming he needs more retainer to eventually reach $50,000, yet he was being paid. Is that reasonable? Is it reasonable that he can state what is and is not reasonable in these regards? Sure, you can get a drink of water.
She does look a little pale.
Just so we are all very clear on this. You are saying all the abuses to the children, schools, police, other judges, families, the FBI, to the United States postal agents, religious organizations, the Jewish Women's Abuse Organization, the Jewish Family Services, teachers, psychologists, doctors, lawyers, school counselors, and the many others, even noted in their very own bills, extortion, collusion, racketeering, identity theft, and identity fraud, the conning, manipulating, hoodwinking, and the psychological warfare waged on entire communities, as a few examples, was necessary. Is that correct? Because the victims want to know. And let's listen to what else you appeared to be confused about.
Getting there.
Well, there was an interruption by you, Mr. Carney. There was a question. But I am having a hard time understanding why we're spending a lot of time on a financial statement that's been admitted by this witness to be inaccurate. I now have in front of me 4 inaccurate statements. So I'm not sure what to make of that.
Well then, let me help you out. There are many, so here is just one.
West's Annotated Code of Maryland. Criminal Law. Title 9. Crimes Against Public Administration. Subtitle 5. False Statements. 9-508. False information in filing statement prohibited. In general. B. A person may not file a financing statement, or an amendment to a financing statement, that the person knows contains false information. Fines and penalties. C. 1. A person who violates this section, is guilty of a misdemeanor and on conviction, is subject to a fine not exceeding $500. 2. Each act of filing a financing statement, or an amendment, to a financing statement, is a separate violation.
That is the lightest one. That was not nearly all of the fraudulent financials filed by Miss Silisky and Mr. Carney. However, those 4 you mentioned comes to $2,000 in fines. Would Mr. Stengel be responsible for the $2,000 as well? If so, would that be assigned to fair, reasonable, or necessary? Or all 3? Should we assume it would categorized with the collusion lunch? There were loads of confessions directly to Judge Judith ENSOR, such as illegally obtaining Alex's passport, a federal crime. Did ENSOR ever report that? Let's look at just one more, for now, given the 4 repeated crimes admitted by Judge Judith ENSOR.
West's Annotated Code of Maryland. Criminal Law. Title 9. Crimes Against Public Administration. Subtitle 1. Perjury. Subsection 9-101. Perjury. Prohibited. A person may not willfully and falsely make an oath or affirmation as to a material fact. 1. If the false swearing is perjury at common law. 2. In an affidavit required by any state, federal, or local law. 3. In an affidavit made to induce a court or officer to pass an account or claim. 4. In an affidavit required by any state, federal, or local government or governmental official with legal authority to require the issuance of an affidavit. Or 5. In an affidavit or affirmation made under the Maryland rules. Penalty. B. A person who violates this section is guilty of the misdemeanor of perjury and on conviction is subject to imprisonment not exceeding 10 years. Contradictory statements. C. 1. If a person makes an oath or affirmation to 2 contradictory statements, each of which, if false, is prohibited by subsection A of this section, it is sufficient to allege, and for conviction to prove, that one of the statements is willfully false without specifying which one. 2. If the 2 contradictory statements made in violation of paragraph 1 of this subsection are made in different counties, the violation may be prosecuted in either county.
However, all of that is for normal judges. You know, the ones with a conscience, which can be evidenced by.
I'm not sure what to make of that. He is the driving force behind this litigation, and I don't think he thinks he is. And that's one of the problems. I don't know if it's this diagnosed mental illness.
In this one tiny instance, we don't have two contradictory statements, rather four. That alone holds a maximum prison sentence of 40 years.
You will need a calculator if you plan on adding up all the prison time.
Judge Judith ENSOR thinks about, discusses, chooses and decides to manufacture events in regards to Mr. Stengel and the crimes, like just mentioned, and the lying to police one. ENSOR also mentioned, although it's a crime for her not to report crimes, instead states
what he thought were Ms. Selesky's discretions and indiscretions. What he thought were Ms. Selesky's discretions and indiscretions. Dr. Lyon testified that Mr. Stengel's been diagnosed with schizophrenia. Dr. Lyon testified that Mr. Stengel's been diagnosed with schizophrenia.
She can't seem to pick a lane, when in reality, there is obviously only one lane. However, she chooses a virtual lane. Picture a roulette wheel, where she puts chips on every number/answer, but the correct one. Besides, where did she come up with the whole Mr. Stengel thought garbage? Apparently, Mr. Stengel is a schizophrenic, with one hell of an imagination.
Go on, show them.
This letter is dated October the 9th, 2012. From Mr. Bradford G. Y. Carney, Miss Selesky's attorney to the courts, and specifically Judith Judith ENSOR. This, in response to Mr. Stengel's request to have the current protective order from the appeal on April the 12th, 2012, rescinded. This appeal was derived from the second fraudulent protective order, dated November the 23rd, 2011, known as the Altered Evidence Trial. During the appeal on April the 12th, 2012, Miss Selesky confessed to altering the evidence, in cooperation with her attorney, Bradford G. Y. Carney. Royston, Mueller, McLean and Reed, LLP. October the 9th, 2012. Hand delivered to
Judge Judith C. ENSOR. Dear Judge ENSOR, as I'm sure you recall, Mr. Stengel is subject to a final protective order issued by Judge Martin on April 12, 2012, which order is to expire by its own terms on October 12, 2012. Although the protective order is to expire, Mr. Stengel filed a petition to modify/rescind protective order on September 28, 2012, along with approximately 150 pages of attached narrative, emails, and pictures which, according to Mr. Stengel, document Mrs. Stengel's made-up lies and many serious crimes, federal and state. It would appear from Mr. Stengel's petition, that he has never stopped obsessing about his wife's imagined lies and crimes, and notwithstanding Dr. Lyon's testimony, continues to demonstrate that he has not overcome his very significant mental health issues. It is my understanding that Mrs. Stengel will be applying to extend the existing protective order for an additional 6 months, which request I assume will be heard by Your Honor, given the procedural posture of this case. Bradford Carney. BC, MJ. Enclosures. CC, Ms. Susie S. Stengel. Mr. Mark L. Stengel. Leon W. Berg, Esquire.
Almost 2 years after their frauds began, we note 1. Mr. Carney notes Mr. Stengel's September the 28th, 2012 filing to rescind the bogus protective order, to remove it from his record. 2. Mr. Stengel included 150 pages of evidence to Judge Judith ENSOR. 3. The 150 pages appear to have been categorized into different criminal jurisdictions. 4. Apparently, the 150 pages are not rambling or incomprehensible, as Mr. Carney was able to clearly delineate. 5.
Imagined lies and crimes.
5a. Apparently, Mr. Stengel's imagination comes with evidence, such as lots of videos, voicemails, text messages, confessions in court transcripts, and even psychotic emails/letters, like this one from Mr. Bradford G. Y. Carney, etc. 6. Now also a doctor. Dr. Bradford Carney diagnoses Mr. Stengel, not free of charge mind you, however, Dr. Carney diagnoses Mr. Stengel as
significant mental health issues.
7. They keyed to this fraud.
I see your rescind of my bullshit and fraudulent protective order, and raise you 1 6-month extension.
7a.
Hey, taxpayer, put the money in.
8. And this goes to none other than Mr. Carney's crime ring partner, who runs interference for their crime ring. The evil and pathological, and the alleged best interest attorney, Leon W. Berg, Esquire. A.K.A. Leon, the liar. Fact, Miss Selesky and Bradford G. Y. Carney did in fact file the fraudulent extension, as mentioned in his letter, which led to the October 25, 2012, trial. Fact 2, although false. However, even if true, Miss Zaleski has no problem with her children's father being disparaged, nor does Mr. Leon W. Berg. Fact 3. Mr. Stengel's September the 28th, 2012, rescind filing, never surfaced, and is apparently lost in the bowels of the Circuit Courthouse, in Towson, Maryland, USA. Really?
It seems more likely that 150 pages of papering became Judith ENSOR's trash paper.
Now, for just one of the hundreds of imagined lies and crimes, there were several dozens of Miss Zaleski's crimes with evidence provided to Mr. Carney, Mr. Berg, Dr. Killeen, Mr. Lazaro, Judge Judith ENSOR, and many others, such as this one, provided very early on. However, to further document realities, this was sent separately on December the 26th, 2011, at 5:05 p.m., 9 months prior to this false statement provided to the courts. Mr. Stengel sent Mr. Bradford G. Y. Carney and copied his associate, Samuel Crystal, this email, with the subject title, "You have been notified of a federal crime." The following attachment is noted at the bottom of the email.
Now, you're not in trouble for getting into his account, are you? Because I would crack his password for you to do this. Now, you're not in trouble for getting into his account, are you? Because I would crack his password for you to do this.
Let's listen to Mr. Bradford G. Y. Carney's own crime ring partner, and the very person Mr. Carney is addressing his letter, Judge Judith ENSOR. Reference what Mr. Carney disparages Mr. Stengel, the children's father, about, and considers imagined.
I now have in front of me 4 inaccurate statements.
And 8 months after this, on July the 22nd, 2013, Mr. Leon W. Berg responds to Mr. Stengel's complaint to the Attorney Grievance Commission of Maryland. Mr. Berg provides his repeated mantra.
Again, the recurrent theme is that Mr. Stengel presents what he considers to be evidence of his wife's misconduct or dishonesty and infers that this evidence must have been ignored by the best interest attorney.
Note, on top of that, although it's right in front of you, you can't see it, therefore, we look closer, as Mr. Berg is falsely representing Mr. Stengel, as he writes,
Mr. Stengel presents what he considers.
That's not what Mr. Stengel considers. In fact, in Mr. Stengel's 7-inch high complaint, and in the 33-page table of contents portion, the words misconduct, or dishonest, was not stated even one time. However, the word crime was stated 11 times. It's Mr. Berg who does not even consider Miss Zaleski's crimes misconduct or dishonest. Mr. Berg again falsely represents Mr. Stengel when he writes,
and infers.
Mr. Stengel didn't infer anything. The word fraud is repeatedly stated. And for the rest of that sentence, just hang out a few minutes. We will be right back. And 10 months after Mr. Carney's letter, and only 2 months after Mr. Berg's response, comes this.
Mr. Rudo, I already know that Ms. Stengel hasn't always been honest. I know that. I know she lied to the police officer because she had Mr. Stengel's phone when she said she didn't. So I know that. And it didn't escape my notice that there were several discrepancies in the financial statements. In fact, in that hearing we had, that lasted several days, it was like every day. Actually, I would get a before lunch and after lunch amendment. So, I mean...
And only 20 pages after that, comes this.
Very little of my perspective on this case had much to do with what Ms. Zaleski said, or didn't say, or did, or didn't.
Therefore, when Mr. Leon W. Berg responded to the Oversight Commission, stating,
and infers that this evidence must have been ignored by the best interest attorney,
Mr. Berg's attempt to redirect the focus onto Mr. Stengel as the one making false claims, we again have reality. It's Mr. Berg, in a classic allegations equals confessions action, confessing to just that. It just took Mr. Berg 2 months to confess in court and on the record. And 9½ months after Judge Judith ENSOR's confessions comes this.
What he thought were Ms. Zaleski's discretions and indiscretions. What he thought were Ms. Zaleski's discretions and indiscretions.
There you go. the circle of psychosis. Same exact actions, with different backgrounds. The circle of psychosis goes around and around.
He is the driving force behind this litigation.
Now, where were we? Right.
I'm not sure what to make of that.
Have you looked in your crime ring's bank accounts?
I'm not sure what to make of that. I'm not sure what to make of that.
Let's see now. 10 months later, this is what you made of that. $179,800 of fraudulent judgments.
Did I hear that right? How much did you say?
$179,800 of fraudulent judgments.
Now that's criminal.
And Mr. Stengel can do this.
18 The United States Code 1961, definitions. As used in this chapter. 1. Racketeering activity means a. Any act or threat involving murder, kidnapping, gambling, robbery, bribery, extortion. B. Relating to counterfeiting. Relating to fraud and related activity in connection with identification documents. Relating to fraud and related activity in connection with access devices. Relating to wire fraud. Relating to financial institution fraud. Relating to obstruction of justice. Relating to obstruction of criminal investigations. Relating to the obstruction of state or local law enforcement. Relating to tampering with a witness, victim, or an informant. Relating to retaliating against a witness, victim, or an informant. Relating to false statement in application and use of passport. Relating to forgery or false use of passport. Relating to misuse of passport. Relating to fraud and misuse of other documents. Relating to trafficking in persons. Relating to interference with commerce, robbery, or extortion. Relating to racketeering. Relating to the laundering of monetary instruments. Relating to engaging in monetary transactions in property derived from specified unlawful activity. Relating to interstate transportation of stolen property. State means any state of the United States, the District of Columbia, the Commonwealth of Puerto Rico. 3. Person includes any individual or entity capable of holding a legal or beneficial interest in property. 4. Enterprise includes any individual, partnership, corporation, association, or other legal entity, and any union or group of individuals associated in fact although not a legal entity. 5. Pattern of racketeering activity requires at least 2 acts of racketeering activity, one of which occurred after the effective date of this chapter and the last of which occurred within 10 years, excluding any period of imprisonment, after the commission of a prior act of racketeering activity. 6. Unlawful debt means a debt, a. incurred or contracted in gambling activity which was in violation of the law of the United States. 9. Documentary material includes any book, paper, document, record, recording, or other material.
Mr. Stengel's daughter had gone to Garrison Forest School. This school has an impeccable reputation, and takes their reputation seriously, as they should. Mr. Stengel never had any problems with Garrison Forest School, or Boys Latin School. In fact, Garrison Forest School had asked Mr. Stengel to coach their 7 to 8-year-old girls' basketball team. Just a few weeks later, Miss Silisky filed what was to be her first fraudulent and false protective order, on November the 29th, 2010, and involved Garrison Forest School and Boys Latin School in that very filing. School records show, shortly after that, Miss Silisky made attempts to further involve Garrison Forest School and teachers. For example, one memo notes Miss Silisky's attempt to get one teacher to testify in court. Testify, not to anything this teacher witnessed, rather to what Miss Silisky had told her. As with all of Miss Silisky's statements and emails. In essence, trying to hoodwink people to repeat what she is saying, rather than any first-hand experience or reality. And the reason they all kept coming up empty.
They think you're psychic. They think you're crazy, okay? They know you're crazy. They've been listening to the stories I've been telling them. They know you're nuts.
Noted in this internal memo, a mere 4 days after her fraudulent filing.
The mom called Jen Traub this morning, and asked her if she would testify.
Ms. Silisky's efforts to hoodwink the teacher did not work, stating,
"As a teacher, school policy says I should not get involved."
Miss Silisky, who doesn't care about her own children, surely could care less about any teacher or school. Now angry, and not happy with that result, responds, and resorts to her usual bullying tactics, thereby attacking the school and its integrity, by stating,
If it ultimately was to the detriment of the child/student, where does Garrison stand?
Apparently, the school stood with their years of internal memos, otherwise known as reality.
And of course for that, I only have the pleadings filed and the descriptions delineated in the bills themselves.
Mr. Stengel filed for a divorce. What ensued after that was nothing short of abusive, and at times, barbaric. Mr. Leon W. Berg received the school's records early on, which he provided copies to Dr. Catherine Killeen, but not to Mr. Stengel. Mr. Stengel was unaware of those records, and several months later, subpoenaed the school, and received their internal memos. The school kept records going back years. Without any doubt, Garrison Forest School was the single best and most reliable outside, third-party, independent source of information. These internal memos, among other things, contained years of many of Miss Zaleski's calls and emails to the school, and the many teachers and staff. Emails, which Miss Zaleski intentionally did not copy Mr. Stengel on. The documents describe Miss Zaleski's actions and interactions with many of the school's teachers, principal, staff, and even their 7- and 8-year-old students, etc. Many are difficult to describe, but extremely disturbing comes to mind. The headmaster of the school told Mr. Stengel their school never had 3 attorneys come at them like this. Those 3 were obviously Mr. Bradford G. Carney, Mr. Robert Wayne Lazaro, and Mr. Leon W. Berg. This upset Mr. Stengel, who then asked Mr. Lazaro to not contact the school for any reason. Mr. Stengel thought, how could that remark by the headmaster in any way be good for his daughter? Then thought, what the hell is the matter with these people? Between Miss Zaleski harassing the school and teachers, to be involved in a divorce, which the memos show they declined, and these attorneys attacking the school, for whatever reason, or reasons, the school felt the necessity to put it in writing. That letter clearly stated, they cannot, and will not, be involved. Even though Mr. Leon W. Berg and Dr. Catherine Killeen were in possession of the internal memos, they continued interrogating the school, with their calls, emails, forms for teachers to fill out, and whatever else they could think of. The number of entries in their bills, given what was already provided, was, and is, outrageous. They were simply harassing and abusing the school, its teachers and staff, looking for dirt on Mr. Stengel. Besides both contract state independent investigations, they both went on the offensive. Their bills clearly show them both tag-teaming the school, its teachers, and staff. Therefore, even with the best-case scenario, Mr. Berg would have entered his information in Dr. Killeen's one ear, and extracted it while questioning her on December 1, 2011, from her other ear. Surely going line by line makes that obvious and unethical for both Leon W. Berg and Dr. Catherine Killeen. However, Mr. Leon W. Berg, nor Dr. Catherine Killeen, ever provided a scintilla of any memos provided by the school, in their proper context, to anyone, including the court, as those records were very bad for their cause. Neither ever made any mention of any of those records obtained, until Dr. Killeen took the stand, and used the school's good name, as she and Mr. Berg twisted things to suit their agendas. Nor was anything they harassed the school, its teachers, and staff for, such as their meetings, calls, forms for teachers to fill out, as noted in their many bills, ever provided, or used in any way whatsoever. Not one. Proving yet again, they were simply interrogating the school, looking for dirt on Mr. Stengel, which they long knew didn't exist. And like them all, they just kept coming up empty, yet kept fishing in their dry cement pond. Therefore, their abuses to the schools, teachers and staff were simply to generate more counterfeit orders. And like the taxpayers footing the bills for all of their frauds, so did the schools, as their resources were used and abused as needed. Like the taxpayers, so too should they pay the schools for their scams. Just by a glance, and on just 2 of the pages, you can see the web of deceit, and their all-out attacks. You can see Mr. Carney was also involved, as Miss Zaleski made sure of that. Although Mr. Berg and Dr. Killeen were each contractually obligated to do independent investigations, it's clear they tag-teamed the schools, their teachers, and staff. Then Dr. Killeen was to opine as an expert on her findings. However, they didn't find anything, as they were only looking for dirt on Mr. Stengel. But they sure did try, and try, and try, and harass, abuse, con, and manipulate. Regardless. Best case scenario, Mr. Berg would be providing his own information to his so-called expert, then extract his own information from Dr. Killeen's avatar-filled ear. Eventually, to yet again, falsely opine for what they manufactured, while using the school's good names as their source for credibility. Sound familiar? Sound familiar? Again, this is just 2 of the pages. You will notice the records were requested weeks after they began. However, what they did with those records is more telling. Mr. Leon W. Berg receives 80 pages and magically reviews them in 15 minutes, which includes a letter to Dr. Killeen. Even if we ignore the time spent on the letter to Dr. Killeen, that's 8.8 seconds per page. No dirt, next page. No dirt, next page. No dirt, next page. Then, after all of that, they continued their abusing the schools, teachers and staff. Surely Mr. Berg and Dr. Killeen will be reimbursing the schools for their resources used and abused with predetermined agendas. However, what they did find, they did not like and never mentioned a word to anyone.
I went through the bills. I went through them line by line. I studied the descriptions of the work performed.
Records which contain internal information such as,
the bigger issue is Susie. She baits Maya, she eggs it all on.
It further states,
Mom doesn't like her being in the low groups, and is making a huge deal in front of Maya, and is making her feel inadequate.
Here you got a 70, which is basically failing, okay? Here you got a 70, which is basically failing, okay?
Not only were Leon W. Berg, Dr. Catherine Killeen, and Bradford G. Y. Carney not outraged by these memos, they encouraged it, and, themselves, applied as much abuse as possible. There are many of these, and obviously the reason Miss Silisky never copied Mr. Stengel on these emails. There are emails of allegations, accusing the school, other students, and even involving parents, of wrongdoing, yet contain contradictions within the same email. Not just blaming others, but blaming others for what never occurred in the first place. There are multiple emails where Miss Silisky says she can't explain her feelings, therefore, can the school explain this to Maya? Basically asking the school to parent her child. This is well documented, and in multiple emails. It is apparent Miss Silisky can't explain that which she does not have. Feelings. The reason so many of the internal memos describe unwarranted aggression, even towards 8-year-old little girls. Because, without the ability to feel, these actions don't bother her, and the reason the actions are so easily, and often repeated. Although the school asked to not be involved, and even confirmed that in a written letter, throughout the divorce, and in different proceedings, Garrison Forest School's name was brought up multiple times. By Miss Silisky, and forwarded by Mr. Carney. Even by Leon W. Berg, and Dr. Catherine Killeen, during her onslaught of false testimony on December 1, 2011. Using the school's name, and twisting the facts, to suit their agenda. Mr. Stengel had thought, they are not only using the school's name, who asked not to be involved in any way, but falsely, and within an agenda, to cause harm to children. Actions, going against the school's demands, also came after Miss Silisky had confessed to wrongfully involving both children's schools. Garrison Forest School, and their headmaster did what was best for their school, teachers, students, families, and extremely important, their reputation, and completely disconnected themselves. However, Boys Latin School, and their headmaster Christopher Post, fell hook, line, and sinker for all their lies and scams. Having Bradford G. Y. Carney as an alumni made their abusing the school easier. For this presentation, we will stay focused on Garrison Forest School, as you will soon learn why. What was the outcome of all their infiltration of the schools, abusing and harassing teachers, staff, and everyone in their paths?
2. Responsibilities. 2.2. Child's best interest attorney. The attorney should ensure that the child's position is made a part of the record.
Not only were neither of the children's wishes put on the record, they in fact did the complete opposite of what they were told by the children.
It's August 26th at 9 a.m. and if anyone hears this, I just want to stay with my dad. By that I mean like full custody with my dad.
Is Dr. Catherine Killeen evil? Doctor quits for non-payment, but really to avoid cross-examination. This will always be known as the paragraph. The paragraph that nails the coffin shut, they thought. after 3+ hours of Dr. Catherine Killeen's colluded, false testimony on December 1, 2011, regarding the father, lasting 80 pages, where all evidence points in the complete opposite direction. What was sworn to in total about the mother, so Judge Martin could make a fair and rational decision, extremely crucial to the children's lives, was completely contained in this one paragraph.
I think Mr. Stengel's he's got some real tough work ahead of him. I'm not trying to paint Ms. Stengel as perfect by a long shot. I think she's got her difficulties, she's got her issues. I think she has taken it on to address some of them in a responsible way. And I think she's also had to just sort of, live a little bit of a bunker mentality, because you can see the amount of material that's come down in this case. And I'm not personally involved, and there have been many a day where I have just felt overwhelmed. So I can't imagine that a reasonable person, including the kids, would feel overwhelmed. That's the end of my testimony.
The children lose 100% communication with their stay-at-home father. Ongoing question: is anything you have seen, or will see, reflected in this paragraph? Case is still going on. Father will never give up on his children. As promised, Dr. Catherine Killeen's confession. One of many, but the key one. Remember, allegations equals confessions. As evil goes. Because of his intelligence, constant complaints, deep desire, reports, letter, and his many documented personal audio journals, you will hear Mr. Leon W. Berg, at the end, confess to who they all brutally targeted. Unethical psychologist forces children into delusional world. Some may ask the father, so why publicly expose this? How can this be a good thing for the children? It was answered by Dr. Catherine Killeen on pages 54 to 55.
So what happens when somebody's being kind of spoon-fed or force-fed a worldview that doesn't really match with their experiences is that you're undermining their sense of reality. And that, to me, is the most damaging of all. Because if I can't trust my judgment about what's real and what's not real, I am in big trouble. I don't know what people to trust. I don't know what institutions to trust. It undermines any sense of self-integrity, self-confidence. It's a very, very devastating condition, and it sets up...
And would it be more so at Alex's particular age?
When we are done, hopefully we will be successful at shoving our delusion down your throats as reality. And your own experiences, with your mother and father, your reality, you must come to realize, you are just delusional.
In reading any of Dr. Catherine Killeen's sworn testimony under oath and the penalty of perjury, in order to keep their colluded stories straight, they simply switched the names. Guess what happens when you read Dr. Killeen's testimony, like her 80 pages regarding the father, and replace the father with the mother? All the evidence, magically, lines up.
It's a very, very devastating condition, and it sets up...
And would it be more so at Alex's particular age?
Dr. Alan Kimmel, Ms. Stegel's medical doctor, aware of Ms. Stegel's mental health issues.
It's a very, very devastating condition, and it sets up...
And would it be more so at Alex's particular age?
It's August 26th at 9 a.m. and if anyone hears this, I just want to stay with my dad. By that I mean like full custody with my dad.
Besides the fraudulent child custody scam on May 1, 2012, every time Mr. Stengel attempted to modify custody, Mr. Leon W. Berg cock-blocked the motion, with the help of his criminal gang, and of course, Judge Judith ENSOR. Court record number 89/0. File date, August 28, 2012. Entered date, August 28, 2012. Document name, Supplemental Motion to Enter Judgment, in favor of Custody Evaluator, in compliance with a court order. Filed by Attorney Leon W. Berg, Esquire. Decision. Granted. That very day. Granted. Mr. Leon W. Berg, as you will learn, represents many people against Mr. Stengel and his minor clients. Although Judith ENSOR grants this obvious fraudulent and illegal act, Mr. Berg never entered his appearance as representing Dr. Catherine Killeen, or anyone else, for that matter, except for the minor clients he was abusing. Besides the order for multiple affidavits we reviewed earlier, and many other times, you will also notice it says supplemental. Therefore, this was not the first motion filed by Mr. Leon W. Berg as representing Dr. Catherine Killeen in getting her fraud and counterfeit orders paid. Mr. Berg, thereby creating his own counterfeit orders, plural, as there were more than one, which Mr. Berg demands Mr. Stengel pay for those orders as well. Then, Judith ENSOR not only grants this fraudulent counterfeiting, but states,
necessary and put each charge as to each will fair and reasonable.
And Mr. Stengel can do this.
West's Annotated Code of Maryland. Criminal Law. Title 3. Other Crimes Against the Person. Subtitle 7. Extortion and Other Threats. Extortion by false accusation. Prohibited. A person, with the intent to unlawfully extort money, property, labor, services, or anything of value from another, may not falsely accuse or threaten to falsely accuse another of a crime or of anything that, if the accusation were true, would tend to bring the other into contempt or disrepute. Penalty. B. A person who violates this section is guilty of a misdemeanor and on conviction is subject to imprisonment not exceeding 10 years or a fine not exceeding $10,000 or both. Isn't that the executive director's son? Caminets. I believe it is. Dr. Alan Kimmel, Ms. Stegel's medical doctor, aware of Ms. Stegel's mental health issues.
And Mr. Stengel can do this.
West's Annotated Code of Maryland. Criminal Law. Title 3. Other Crimes Against the Person. Subtitle 6. Abuse and Other Offensive Conduct. 3-603. Sale of minor. Prohibited. A person may not sell, barter, or trade, or offer to sell, barter, or trade, a minor for money, property, or anything else of value. Penalty. B. A person who violates this section, is guilty of a misdemeanor and on conviction, is subject to imprisonment, not exceeding 5 years, or a fine not exceeding $10,000 or both, for each violation. May I ask a question?
Of course.
Whatever became of Mr. Stengel coaching the Garrison Forest School basketball team?
It will be easier to start with how it began. On November 2, 2010, the school was looking for volunteers.
From Zabi Andrews. Sent, Tuesday, November 2, 2010, 7:43 p.m. to markall@stengels.com. Subject, Basketball at Garrison Forest School. This league is run entirely by parent volunteers. In order for us to participate, we must have 2 parent coaches per team. We tried to get involved last year, but did not have enough parent support. So please consider helping your daughter get involved in a fun, competitive basketball experience by volunteering to coach.
Mr. Stengel sent Garrison Forest School an email offering to help. Miss Silisky sends an email to Garrison Forest School. From Susie Stengel. Sent, Wednesday, November 3, 2010. 7:36 a.m. to MS Global 2. Mr. Stengel. CC, Zabi Andrews. Head of Lower School.
Subject, regarding basketball at Garrison Forest School. Zabi, this is an area where Mark excels. He really missed his professional calling. He has a natural ability to utilize each player's individual talents/strengths. Pulls a team together well. Susa Sileski Stengel.
From Tracy Davis. Sent. Friday, November 5, 2010, at 11:25 a.m. to MS Global 2.
Subject, regarding basketball at Garrison Forest School. Hi Mark, we'd love to have you as our 3rd/4th grade coach. Tracy Davis. Director of Athletics. Garrison Forest School.
Note, November the 22nd, 2010, as it relates to Garrison Forest School. Looking at the months of video clips, they also show Miss Sileski would only have arguments with the kids present. Quite bizarre. Mr. Stengel would leave the room, she would follow him, then scream, where from upstairs, with no cameras, she could be heard from the lower level cameras. Therefore, leaving the room became pointless. On multiple occasions, she insisted on having these, right then and there, prior to Maya or Alex going to school, and in this case, Maya being there. This was about Alex, and his father laying in bed at night reading, when Alex tells his father, he really wanted to spend Thanksgiving with his older brother, Scott. Mr. Stengel asked Scott to go to New Jersey. He didn't want to, since he spends part of the day with his mother. After Mr. Stengel told Alex, Alex asked if they could do Thanksgiving at the house. He mentioned that to Scott, who said he would love that, and will help with everything, and spend the entire day, and go to his mother's for dessert. Alex was very happy. Alex had already left for school. However, he had already told his mother, it was his idea. This is a 13+ minute clip, although shown in full in the timeline, we will just show some portions, and the end, as it relates to involving Garrison Forest School. These clips are in timeline order.
I'll make it easy. I'll go by myself. And I won't come back.
That doesn't
Ever.
help them.
Ever.
That's what you're saying to Maya?
I'm saying it to you. I will take my kid. Good.
Okay.
Then that's what he's going to do.
That
because
shows,
he's
no, he
a
wouldn't. He
child.
said he wouldn't.
Well, then we're not going to beckon to his will. It's all about Scott. Are you kidding me? The rest of us have to suffer because Scott Stengel has decided we're not going to. Yes, because I want to be with my mother on Thanksgiving, and I want to be with my cousins on Thanksgiving.
Then go. Then go.
And that's my ask. Do you want to be with Jessica and Nicole on Thanksgiving?
What are you involving Maya for?
Because she already told me she does. Why are you penalizing her? Why are you penalizing her?
What adult does that?
When was the last time they saw their cousins Sean and Drew?
What are you doing this in front of her for? Stop in front of her. Could you please stop? Just stop.
You have cameras to make sure you know everything that's going on.
You can't be doing this in front of your 8-year-old boy. Do you understand that part?
Yeah, I understand. But you should make sure that your wife pales to your 22-year-old precious son. And we should all do what the 22-year-old wants to do because he doesn't want to go to New Jersey. I totally get who lies in this family, and it ain't me, Mr. Stengel. Let's go, Maya.
Hopefully.
With your lunch. So glad this happened.
What followed is noted in this Garrison Forest School internal memo.
November 22, 2010. Mrs. Stengel and Maya seemed very upset, as they waited outside the classroom to enter. Mrs. Stengel asked to see me right away. At this point we went to my office, where she explained intense conflict which took place between she and her husband. She shared they got into about how they'd spend Thanksgiving, and reports he wants to remain home with his oldest son, her stepson, and she wants to keep plans she had with her family in New Jersey. She reports losing it, which resulted in lots of yelling and screaming in front of Maya and her brother. She expressed lots of remorse, frustration, and sadness, as she cried in my office about the ongoing conflict they've experienced. She asked if I could see Maya to help her process.
Note, remorse, not possible. Cry equals crocodile tears. And can Garrison Forest School parent my child. Translated.
I will screw her up. You fix her.
Note, yes. Mr. Berg and Dr. Killeen received all of these, and dozens more videos and Garrison Forest School internal memos. In fact, in presentation form, as well. Mr. Stengel was unaware of what took place at the school. That same morning, Mr. Stengel received an email from Garrison Forest School.
From Tracy Davis. Sent, Monday, November 22, 2010. At 8:44 a.m. To Gretchen, and MS Global 2. Subject, Junior Grizzlies Basketball. Good morning Gretchen and Mark, we have had a terrific response to this first year of Junior Grizzlies Basketball. We will have 2 3rd/4th grade teams. 16 players, and 1 5th/6th grade. 10 players. Your first practice will be on Wednesday, December 1st. Tracy Davis, Director of Athletics. Garrison Forest School.
A couple things worth noting. 1. The year before, they could not get enough parents to help. 2. This is the school's first year. 3. They need 2 parents per team. Originally had 2 teams, Now there are 3 teams. 4 emails sent to the only 2 coaches the school could get, Gretchen and Mr. Stengel. 5. First practice will be on December the 1st, 2010. Note, now with the school having 3 teams, he was sure he was going to get both of the 3rd and 4th grade teams. Mr. Stengel was already coaching Alex's recreation league basketball team. It didn't matter, since he knew it was important to Maya, as she had been telling all of her classmates, her father was going to coach the school's team. When he would pick Maya up from school, many of the girls excitedly were coming up to Mr. Stengel. November the 29th, 2010. Ms. Silisky files her first fraudulent protective order. Time stamped at 8:53 a.m. However, at 6:39 a.m., 2 hours 14 minutes earlier, Miss Silisky is asking Mr. Stengel to take out the trash. Surely, Mr. Berg remembers this video, as well. Besides, Mr. Stengel is so put off by her, he can't even bear to look at her, or listen to her.
You didn't take the recycle out. You're going to take it out? They're driving around the driveway. You're not going to take all this trash out?
Yeah.
But they're out there now. Why wouldn't you just take it out? Why wouldn't you empty the trash can? I don't understand. Huh?
Okay.
But today's the recycle day. It's a recycle bin.
Miss Silisky's fabricated laundry list of false allegations. 27 actions, such as L.
He is using morphine and Ambien to get high.
R.
Not to go to schools.
Checked.
Boys Latin School. Garrison Forest School.
T.
To turn over firearms.
Checked. X.
To go to counseling for drug and alcohol.
Checked. Y.
I solemnly affirm under the penalties of perjury, that the contents of the foregoing petition, are true to the best of my knowledge, information, and belief.
However, that is not what Miss Silisky provided to the schools. These are from Garrison Forest School's internal memos. November the 29th, 2010. Temporary Protective Order. Susan Silisky versus Mark Stengel.
C. That there are reasonable grounds to believe that respondent committed the following abuses. Stalking. Hidden video cameras in home. Past history of physical assault in May. Other cyber stalking. That the respondent has access to firearms. Based on the foregoing findings, the court hereby orders 1. That the respondent shall not abuse, threaten to abuse, or harass Susie Silisky Stengel, Maya Stengel, Alexander Stengel. 2. That the respondent shall not contact, in person, by telephone, in writing, or by any other means, or attempt to contact, Susie Silisky Stengel. 3. That the respondent shall not enter the residence of Susie Silisky Stengel or at 3743 Birch Lane, Owings Mills, Maryland, 21117. 4. That the respondent shall stay away from school, Boys Latin School, at 822 Lake Avenue 21210. And Garrison Forest School, at 300 Garrison Forest Road 21117. 5. That the respondent shall vacate the home, immediately. 6. That custody of Maya Stengel, Alexander Stengel, is awarded to Susie Silisky Stengel. 7. That the respondent shall surrender all firearms to law enforcement agency. That custody of Maya Stengel, Alexander Stengel is awarded to Susie Silisky Stengel. November 29, 2010, at 10:15 a.m. Judge, Kathleen G. Cox.
He is the driving force behind this litigation.
Besides all the danger garbage, the one most disturbing is,
based on the foregoing findings, the court hereby orders. Based on the foregoing findings.
Because series number 1, episode number 1, clearly identifies many times where Miss Silisky's sworn filing, which Judge this Kathleen Cox had in front of her, contradicts Miss Silisky's sworn testimony, who is now standing in her courtroom. Surely a circuit court judge knows how to play concentration. Filing says son, testimony she swears, children, plural. No match. However, not one of the many contradictions were even mentioned. It may have sounded like this.
Excuse me, ma'am. Your sworn filing, just an hour ago, says A, and now you are telling me, B. Which is it?
That also doesn't take into consideration, Miss Sileski looked like she just arrived from breakfast with friends, not a woman in distress or fear. Furthermore, if someone is in fear for their life, why would they want to go to a location their alleged abuser will know where she is? Among many other reasons, laid out in episode number 1, which contains 27 filing actions and 48 sworn testimony actions. She is either a sleeping judge, playing solitaire back there, or couldn't care less. Or, all of the above. After Miss Sileski's failed attempt, using Maya to call her father at 4:19 p.m., to lure him from the home, 2 sheriffs arrived. Mr. Stengel is evicted from his own home at 7:48 p.m. A mere 50 minutes later, Miss Sileski arrives, with hacker number 1. This hacker's name, John Seville. The same John Seville, Miss Sileski told police officer Bell on November the 27th, 2010, whose house she was going to, after lying about stealing Mr. Stengel's password-protected phone. The same John Seville, who evaded service. Then, at a later date, Mr. Stengel had a subpoena delivered to his work. After being subpoenaed, Mr. Seville sent a letter about being harassed to Judge Judith ENSOR, requesting his subpoena be quashed. Mr. Stengel responds with 14 pages, including a letter, many videos, those and other photos. Then, on National Quashing Subpoenas via Fraud Day, November 26, 2012, the transcripts notes Mr. Stengel, regarding Mr. Seville, on page number 11, and pages 24 to 25. Mr. Stengel's subpoena. Rejected. After all, federal crimes are not Judge Judith ENSOR's thing. Apparently, that falls under the Fair and Reasonable Act of... What year was that? Right, the year of psychosis.
There are rambling emails and irrelevant subpoenas. He is the driving force behind this litigation. The number of emails that people had to review, he is just papering them to death. Fair and reasonable.
And, what about the basketball practice scheduled for December the 1st, 2010?
Mr. Stengel was not even permitted on the school grounds.
So this Gretchen woman had to do it all by herself.
Yes. However, that's not Miss Sileski's problem or concern.
Just so I understand, a few weeks earlier, Miss Sileski recommended Mr. Stengel coach 7- and 8-year-old little girls. And now, Mr. Stengel is too dangerous to be around his own children.
Correct?
And Mr. Berg and Dr. Killy both received all of this.
And much more. At a minimum, the information in the many presentations. In fact, Dr. Catherine Killeen stated she was at times overwhelmed. She just left out the part. Overwhelmed with evidence which contradicts everything she is swearing to, under oath, as Mr. Berg's expert witness. The following day, November the 30th, 2010, it's a hacker party. We have hacker number 2, and the infamous video taken at 1:26 p.m. Alex and I were both home, as this stranger sat at their father's desk. Alex recalled, his mother kept asking one hacker,
"Are you in yet? Are you in yet?"
Now you're not in trouble for getting into his account, are you? Because I'd have cracked his password for you to do this.
Fair and reasonable. I only have the, and of course for that, I only have the pleadings filed and the descriptions delineated in the bills themselves.
Bullshit. There are so many confessions. This one just 3 hours later. Mr. Stengel has all of the phone records, and knows who she was speaking with, in each of these.
Now, is really based on, hold on a second, I think she's trying to find someone, and I think I may have found that person, who will say he could potentially hurt me or the children because he's a loose candidate. Okay, so I think that's what she's looking for. If she has that, then she can extend the protective order, which is really what the goal is. Yeah. Well, this is the whole thing of this is exactly the thing. My friend. Okay, so okay, wait a minute. You know what? Let me call you back in a second.
Later that same night, there are many confessions caught on tape. We will only do 3.
I'm kind of screwed in this way because he hasn't physically hurt me. Well, there are no bullets in it. We can't find the bullets at the moment. The bullets are in the house somewhere, but I don't know where. Yeah. He wouldn't have done anything. He really wouldn't have. I mean, honestly, between you and Lanfest, he wouldn't. He had it there because he's got an ego and he's a bully, and he wouldn't have let anybody hurt his kids or his family. That's 100% the truth. That won't help me with the peace order. It has to be some kind of violence within the last 30 days, or threat of violence.
Miss Siliski, the caregiver, takes care of children. That's what Betsy R. Stryker swore to on December the 7th, 2010.
You're going to be sad when I'm walking out the door without you. You're going to be very scared.
I'm having Allison's socks.
These aren't Allison's socks.
Yes, they are. I never wear those socks. Ever in my life. And I think those are my socks.
Well, then I guess you go to school without socks on. I can't go up and get your socks, and you can't get on without them. So, I don't know what to tell you.
Maya, you have 3 seconds to go get your socks and your toothbrush. Let's go. Or no Hanukkah for you tonight. 1.
What's my teeth?
Maya, go get your stuff.
I was getting up. You can't let a girl get up.
You are a difficult one. After buying lunch today.
Okay?
Yeah. You didn't buy yesterday.
Yes, I did.
Oh,
You didn't pack me a lunch yesterday, Mom.
yes, I did.
You packed me a snack
You're right.
and the drink. What? Didn't the judge realize that it was Hanukkah and one was Jewish and that we wanted to see Dad for Hanukkah? Mom?
Listen. The judge did not like several things. I'm not going to discuss them with you because you are a child. It had no idea, listen, he doesn't mean to be punishing anybody. He means to be separating mommy and daddy who are misbehaving in front of children who shouldn't have parents that are misbehaving.
Oh,
And of course for that, I only have the pleadings filed and the descriptions delineated in the bills themselves.
Bullshit. Bullshit.
He's right. It's all bullshit.
Dr. Alan Kimmel, Ms. Steggles' medical doctor, aware of Ms. Steggles' mental health issues.
He is the driving force behind this litigation.
Bullshit.
The number of emails that people had to review.
No time to make lunch. Hell no. Miss Siliski has many more people to con, and many more crimes to commit. Also on December the 1st, 2010, and just a few hours later, at 10:18 a.m., we have Hacker number 3. Miss Siliski was extremely busy, conning anyone and everyone, including her attempt to bully the Garrison Forest school teacher, as documented in the school's internal memos, to testify under oath and the penalty of perjury, just like Betsy R. Stryker and Kelly Weinberg did. She even conned her nephew Matthew to testify, and of course, always more than willing, her adoptive mother, Sally Siliski, aka the money launderer. Susan Siliski always trashed Bobby Siliski, her brother, and Sally's adopted son. However, they collectively trashed and made up lies about Gordon Siliski, her adopted father, and Sally's ex-husband, saying Gordon was violent, threw dishes, and a bad man. Sally, divorced over 25 years, disparaged Gordon constantly and in front of Alex and Maya. Mr. Stengel could not recall even one time Gordon saying anything bad about Sally, or anyone for that matter. Not one time. In fact, these two criminals have their entire family believing that garbage. Then, there is the reality. Gordon was a meek, quiet man who spent much of his time volunteering at food shelters, clothing shelters, etc. In fact, Matthew, Bobby's son, told Mr. Stengel his grandfather would take him places and never once missed sending him a card on his birthday. Mr. Stengel had to ask the obvious question, to which the answer was, he never once received a card or a phone call on his birthday or any day from his grandmother, Sally Friedberg Siliski. Never. It seems very odd, someone that spends so much time volunteering to help others matches with a violent person. Or, its allegations equals confessions. In fact, Ms. Susan Siliski describes her adoptive mother growing up as mean, angry, and selfish. Susan, Sally, and everyone else always called Bobby the protector, always protecting her, and even her friends if needed, growing up. And Susan's friends growing up confirmed it. Yet, when Bobby was living at Sally's house, and Susan stated, if Sally dies, Bobby will have squatters' rights, therefore threatening her inheritance. There will be none of that. So Susan gathered a posse, including Sally, Sally's friends, cousins, aunt, uncle, you name it. To do what? Well, the protector, all of a sudden, became a dangerous person, and Sally's duty was to get a protective order against Bobby, her son. But really, to get him out of Sally's house. Sound familiar? Sound familiar? No worries. There are tons of emails documenting what has been compiled in 3 presentations. Bobby's World, Get Bobby, and Bobby Siliski, The Cost of Protection. And yes, Leonberg, Dr. Killeen, Mr. Lazaro, Judge Judith ENSOR, and even the state's attorney, got all of those, as well. Bobby was suing his sister for shady handling of their father's estate, known as the illegally executed will, where Susan got 100% of everything. Even the 4 grandchildren did not get so much as a pencil. And the fraudulent power of attorney for Gordon, which Bobby documented in the orphans' court records. Miss Siliski was trapped, as Bobby was right, and the dates do not line up for that power of attorney. It should be noted, Bobby had moved back into Sally's house just weeks after his complaints were documented, and at age 46, went to sleep, and never woke up. Gordon was under Susan's power of attorney. Nearing 80, he would hike 10 miles. Wound up in hospice, and was so fit, he lived more than 2 weeks. Gordon's lifelong friend of over 50 years, well, Miss Siliski would not allow him to even say goodbye to his friend. The alienation game. A couple days after Gordon's funeral, and the last time Mr. Stengel had seen Bobby, before his untimely demise, as he left the house, turned to Mr. Stengel, looked him right in the eyes, and said these exact words.
People have no idea who Susie really is.
Turned and left. Ironically, years later, Miss Siliski is sent on video saying the very same thing, telling Mr. Stengel he has no idea who she is. Anyway, moving on. It's all the same sludge she was trying to con Maya's teacher into. Although the teacher rejected Miss Siliski's demand, Miss Siliski was counting on her to swear under oath, not to any personal experience or reality, rather they all testified because
they think you're psychic. They think you're crazy, okay? They know you're crazy. They've been listening to the stories I've been telling them. They know you're nuts.
And testify on. What was Miss Siliski bullying the Garrison Forest school teacher to assist in? Better yet, add to. And what 4 samples, among hundreds, with corresponding evidence, was provided to Leon W. Berg, Dr. Catherine Killeen, Robert Wayne Lazaro, and Bradford G. Waikani, who infiltrated the schools and abused entire communities. Also provided to Judge Judith ENSOR, Judge Kathleen G. Cox, the Attorney Grievance Commission of Maryland, and even the Maryland State's Attorney, all insisted on the driving, and abuses continue. The trial was on December 7, 2010. As you can see, there was a lot of perjury. Not just perjury. Rather, perjury, with the foreknowledge Miss Sileski was going into court with these lies, and bringing others to do the same. Therefore, suborning perjury, as well. 114 actions, in 99 pages. 114 is a low number. Let's look at just 4 of the 114 actions. Miss Sileski's December the 7th, 2010, sworn testimony. Then, we will allow Miss Sileski to show us a full month before, exactly which hidden camera Catherine Barrison found. Which staging apparently took place between November the 29th, 2010, which documents 75 criminal actions, and December the 7th, 2010, which documents another 114 criminal actions.
There was one hidden up on the kitchen shelf, where my baskets are that I use for bread and whatever, hiding between a basket and a Brit box, that my friend Catherine Barrison found.
And it leads to the camera.
No, that's that.
No, because my yelling is from frustration.
No. Yeah, I think, well, I don't know.
Frustration and resentment. And it leads to the camera. And it leads to the camera.
Mr. Carney's bill notes.
November 29, 2011, call from witness Catherine Barrison regarding hearing. 0.10 hour, and billed $20.
He is the driving force behind this litigation.
I'm not taking any medications, and using them incorrectly.
Just 6 weeks earlier. From Susie Stengel, susiestengel@me.com. Sent, Friday, October the 22nd, 2010, at 11:51 p.m. To Mark Stengel. Subject.
Good night. Just took one of Aunt Janet's Ambiens. Headed to sleep. Love. Me. Susie Stengel. Creative Memories Senior Consultant.
Also sent from Miss Sileski's Creative Memories Scrapbook Business Weekend Crop, where she profited over $1,000. Yet 2 months to the day, filed her fraudulent zero income statement. And dated 5 days before its creation.
This is one of those tricky things.
I haven't shown any violence.
Less than 3 months prior. We will slow it down to show the intent of that violent act.
He is the driving force behind this litigation.
Miss Sileski's answer.
My concern is, he's out of control.
Question. What your concerns are about yourself, that is bringing you here, to ask this judge to continue the protective order. Miss Sileski's answer.
He has been physically hurting me.
Just 7 days earlier.
I'm kind of screwed in this way because he hasn't physically hurt me.
He has been physically hurting me.
I'm kind of screwed in this way because he hasn't physically hurt me.
He has been physically hurting me.
Look at all of the fraud Garrison Forest School missed out on. Don't you worry. Since Garrison Forest School couldn't come to the fraud, this crime ring brings the fraud to Garrison Forest School. Sort of a fraud delivery service. Besides, what you will learn is, what appears to be a request, such as this communication, is simply a courtesy notification of what's to come. Like Dr. Killeen, and the medical professionals, and quite frankly, everything, and everyone else. Here, Garrison Forest School rejecting Miss Sileski's offer, is not taken so much as a rejection, rather, the school's opinion.
The number of emails that people had to review, they're unreasonable. He is just papering me to death. He is the driving force behind this litigation.
Bullshit.
He's right. It's all bullshit.
How fearful was Miss Sileski of Mr. Stengel? Well, after losing the court case, came back to the home, saying she was dropping Meyer off, but what fun would that be? Then insisted on coming in, with her 80-year-old mother as security. But really, to cause more chaos, where Mr. Stengel had to call the police. Mr. Stengel had not seen or spoken with Alex or Meyer in 8 days. Miss Silisky lures Maya away. Alex stays, only to be hijacked and held prisoner with Maya.
Please, just stop. Yeah, stop grilling her. Please, just stop. Yeah, stop grilling her.
Getting out of my hand. Maya, what happened? You kept fooling me. We're leaving. Huh? No! No! Weinberg's, let's go. Yes, we are. We're going to Kelly Weinberg's, let's go. Yay! Come on.
Where do you want to go?
I'm going to Kelly Weinberg's.
Let's go.
All right. Sir, where do you want to go?
Stay here. Okay, you stay here. Let's go.
Where do you want to go?
I'm going to Kelly Weinberg's.
Let's go.
All right. Sir, where do you want to go?
Stay here. Okay, you stay here. Let's go.
In regards to the no phone access scam, that fraudulent order on November the 29th, 2010, ordered that Mr. Stengel could not contact Miss Silisky, as noted by number 2.
2. That the respondent shall not contact, in person by telephone in writing, or by any other means, or attempt to contact, Susie Silisky Stengel.
But said nothing about contact with Alex and Maya. Yet Miss Silisky told Alex and Maya their father was not allowed to have any contact with them, and the reason Alex could not come to his basketball practices or games, since his father was the coach. But really, the alienation game. Email. From Susie Silisky. December the 10th, 2010, at 8:26 a.m.
Subject, Alex and Maya Stengel. To Kathy Arnold, head of Boys Latin Lower School. Donna Avila, Boys Latin teacher. Kay Halata, Boys Latin teacher. Deborah Lynn, Garrison Forest School teacher. Cheryl Overend, Garrison Forest School teacher. Zabi Andrews, head of Garrison Forest Lower School. Good morning. Please be advised that Alex and Maya will be taking a personal day today, and will not be attending school. Please send Alex's work home with Jeremy Weinberg. I will pick Maya's work up this afternoon. Should you have any questions, please feel free to contact me. Sincerely, Susie.
Note, papering 2 schools, 4 teachers, and 2 heads of their lower schools. This while Alex and Maya were being held prisoners, at the Weinberg compound. Officer Miller told Mr. Stengel, the Weinbergs did not want him near their home, and if he came around, they would have him arrested. It's also worth noting, especially since Leon W. Berg and Dr. Catherine Killeen were fully informed. Days later, Mr. Stengel went to the boys' Latin school holiday play. Alex was not there. Mr. Stengel took many pictures for Alex. Jeremy Weinberg also attends boys' Latin. He was at his school play. Maya's play began later that day. Mr. Stengel went to Garrison Forest School, and no, Ma. So he stayed and videotaped her entire play, which they all watched, at a later date.
The number of emails that people had to review, they're reasonable. He is just papering to death.
Just 1 hour later. Second email. From Susie Silisky. Friday, December the 10th, 2010 at 9:22 a.m. To Ellen Rosenberg, Ms. Silisky's attorney.
Please inform Mark's attorney that the kids are not in school today so that he does not show up at their schools. Thank you.
Judge Judith ENSOR surely agrees. 1. Ms. Silisky, sending an email to her attorney, and ring up a bill. 2. Have her attorney, inform Mr. Stengel's attorney, and ring up another bill. 3. Mr. Stengel's attorney is informed, and creates a bill. 4. Then informs Mr. Stengel, for yet another bill. Or, Ms. Silisky could have sent Mr. Stengel a text message. But in all fairness, and with the Weinberg compound being on lockdown, it's possible all communications may have been cut, and less, generating any legal bills. Alex is kidnapped. Held prisoner. Not taken to school or his activities, such as the Recreation League basketball, where his father was the coach. School events. And something referred to as freedoms, where he eventually had to escape that prison. Kelly Weinberg, in the psychology field, swore under oath just days before. Miss Silisky loses the case. Then on December 8th, Miss Silisky calls Child Protective Services to remove Alex from a drug-addicted, violent man. Surely you remember Miss Silisky saying,
Okay, you stay here.
When Officer Miller was there, that was the night before. Having lost the case, and Child Protective Services rejected her demands, Miss Silisky takes matters into her own hands, and involves Cheryl McCann, normally a carpool mother. However, on that day, was part of a hostage transfer, and the Weinbergs housed Miss Silisky, and supplied their compound, and maximum security incarceration. That first email went to 6 people at the schools. This one, Miss Silisky sent to her attorney, to send to Mr. Stengel's attorney, and Mr. Stengel. 9 people. Without including the driver. Look. Incarceration, and restraining the liberties of Miss Silisky's own children, is not cheap. Would anyone else like a copy? Surely, there is someone else that needs to know. Miss Silisky is telling her attorney, to contact Mr. Stengel's attorney, to contact Mr. Stengel. The kids are not in school. Note, who else needed to be papered? Let's reveal the mystery receiver.
BCC, Zibby Andrews. Head of Garrison Forest Lower School.
What other task is then required by Zibby Andrews? Really? Zibby Andrews, the head of Garrison Forest Lower School, who also had to print it out and then file it, even though she received that other email an hour earlier, and a blind copy at that, being hidden from Miss Silisky's own attorney.
The number of emails that people had to review, he is just papering like that.
Later that day, Mr. Stengel receives an email from Tracy Davis, sent Friday, December the 10th, 2010, at 4:35 p.m. to MS Global 2. Subject, regarding Garrison Forest School basketball practice today.
Hi Mark, thanks so much for your offer to coach, but we have the coaches we need. Have a good weekend, Tracy Davis.
Note, Mr. Stengel knew that was not the case. They now had one coach that never coached a basketball team. However, she was familiar with coaching, as she coached lacrosse. He also understood the situation the school was placed in, when they were involved by that court order. But felt horrible for Maya, as she was so excited. Even worse, being held prisoner, he could not even tell her. Maya later told her father, she was very upset with her mother, and her mother told her it was not her fault, and the decision was made by the principal, Zibby Andrews. Mr. Stengel, not wanting Maya to be upset with her principal, or anyone for that matter, explained to Maya that she should not be mad at Ms. Andrews, because she really did not have any other choice.
So that's what happened to Mr. Stengel coaching the school's team. Maya was not the only loser in that mess. So were her schoolmates, and the one coach, left to handle it all.
If one could imagine, it got worse yet.
Worse. Regarding the school's basketball teams.
Yes. Follow along. We are almost there. Included in the subpoenaed documents. Note, this was received as seen. Not sure what was redacted. Garrison Forest School internal memo, dated December the 10th, 2010.
I called both parents separately, discussed how all this is impacting Maya, the importance of getting back to some normalcy, developing a schedule, routines, and rituals. At times they each attempted to share frustrations about the other, at which point I remained neutral, and continued to focus on what's in Maya's best interest.
Note, Mr. Stengel tried explaining, with Miss Silisky, and the word, normalcy, is simply not possible. But let's try. The mere fact, that very day, Miss Silisky was holding both Alex and Maya prisoner, and in regards to the no phone access scam, not allowing either Alex or Maya even call their father, also not taking the kids to school, and notified by Miss Silisky's emails, tells the reason for the teacher's calls. If Mr. Stengel had only known about all the internal memos, he could have just referred her there. Kelly and Andy Weinberg refer Miss Silisky to Bradford G.Y. Carney. If you think Garrison Forest School and others had problems before, well, hold on tight. 3 days later, Alex escapes the Weinberg compound. Mr. Carney writes a letter, stating they are keeping Maya until crazy Mr. Stengel is psychologically evaluated, and is deemed no threat to Maya. Classic, redirect focus, then, attack. Mr. Stengel was left no choice, but to file for a divorce, to free Maya from this mess. Meanwhile, Alex, after the escape, told his father, all his mother does, is talk bad about their dad. He asked if that was in front of Kelly and Andy Weinberg. He said, yes. and in front of me, Maya, and the Weinberg kids, Jeremy and his younger brother. And all the time. Alex also said he argued with her, as they were all lies. The most difficult part to hear was Alex said, and Maya believes her. But I kept telling Maya it's not true. You know, Dad. We now skip ahead, and 2 weeks later to the day. December the 29th, 2010, was Exchange Day, where Miss Silisky, although had earlier stated in documents, she got almost everything out of the house, could not pass up any opportunity for more chaos. However, we will only focus on Miss Silisky, exposing Mr. Carney's plan. This plan comes only 2 weeks after Mr. Bradford G. Y. Carney gets involved. It's important to know, Kelly Weinberg is there, assisting Miss Silisky, and listening to Miss Silisky's constant ranting, the entire time. Although in the psychology field, and after Miss Silisky loses the case, where Kelly testified, then Alex held captive at her home, and having Miss Silisky live in her home, not taking the kids to school, constantly trashing their father in front of them. Then Alex escapes her home, now listening to all the ranting, yet again, still can't figure out, there is something seriously wrong with this one. To shine yet another light on all of that. After Alex escaped, Kelly brought some of Alex's things to the house. Mr. Stengel already knew why, but he asked Kelly, why was Miss Silisky staying at her house? Kelly stated,
because she said she has no other place to go.
Mr. Stengel told her that was bullshit, as she and her mother lived with her Aunt Janet, a few miles away for about 2 years, many years ago. Kelly responded,
really?
Yes, Kelly, really. After Miss Silisky left the Weinbergs' home, and for many months, also during this exchange day, guess where Miss Silisky was living? Yes, that same aunt. Aunt Janet. Therefore, confirmed Mr. Stengel was telling her the truth and Miss Silisky had lied to her, just because she had kids Alex and Maya's age, and thought it would be easier to keep them there. Which, if you remember, was how Miss Silisky lured Maya from the home, after losing the trial. And, Kelly had a dog. Maya loves dogs. Everything is a con. Everything. As you will learn, this is not a knock on Kelly, rather information, those even in the psychology field are taken in by these types, time and time again. And now, for the exposing of their plan.
Could you please get out of my face, ugly son of a bitch? Get out of my face. Do you videotape me? Hi, he's a crook. Can't wait till you end up in prison. 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 Can't wait till you end up in prison.
Guess who else assisted in that fraud act? Correct. Kelly and Andy Weinberg. And for that reason, we will inform Kelly Weinberg, she is also a witness to something else. During that exchange day. Yes, the police were there. And being lied to, yet again. As you will hear, the officer was getting angry with Miss Silisky. And now, why Kelly needs to practice her testimony, and what she is a witness to.
Traveling all over the world and bed to
I
bed.
like the wax museum.
Yeah, that was kind of cool, huh?
Mark, why was there a video camera in there that you took out? Why did you take the thing out of there? Why were you
Ma'am, can we just
videotaping
please
me
get
out?
ourselves in charge?
I just want to know why you were videotaping in the bedroom.
I wasn't.
Then why'd you take it out of that cabinet? Why Kelly and I see you?
What are you talking about? What are you talking about? I took what out of where?
I just want to know why you were videotaping in the bedroom.
I wasn't.
Then why'd you take it out of that cabinet? Why Kelly and I see you? Why Kelly and I see you? Why Kelly and I see you? Why Kelly and I see you?
Needless to say, the chaos not only continued, but with Mr. Bradford G. Y. Carney, escalated. And escalated. On January the 2nd, 2011, Garrison Forest School had a basketball game. The only coach they had for all teams was going on vacation. Mr. Stengel was not even asked to help out. Instead, they were forced to ask a parent that really didn't know much about the game or coaching. What ensued was brutal to watch. Mr. Stengel felt very bad for this parent. As you can see, he could not even get their attention. They were trying to take a team photo. Not interested, or very happy. The important thing to remember is, it's not Miss Zaleski's doing, rather the principal, Zibby Andrews' decision. Right, Miss Zaleski?
Dr. Alan Kimmel, Ms. Stegel's medical doctor, aware of Ms. Stegel's mental health issues. So everybody pays the price. The coach who must have felt bad going on vacation, all the girls, that parent trying to help, all the parents watching this, all the girls missed out on learning, by being coached by Mr. Stegel, the school, as that is embarrassing, and the principal, Zibby Andrews, who was blamed for it all. And this was the school's first year to kick off their basketball program. You were right. It did get much worse. Also correct, they didn't have all the coaches they needed.
Footnote. Most presentations have no more than 5% of its content duplicated. Some things are needed to make each presentation stand on its own.
He is the driving force behind this litigation.
Which brings up an interesting point. Are you aware that math is Mr. Stengel's subject of choice? Math is his thing. Which brings up this very point, as it relates to.
He is the driving force behind this litigation.
That one knowingly false statement lasts 2.2 seconds. Did you know that? Well, here are some other numbers that may be of interest. As we specify it, to that very day. Judge this Judith ENSOR's salary, not including benefits, vacation time, and whatever else is stolen from the taxpayers, is $154,433. That comes out to 0.02062 cents per second. Mr. Bradford G.Y. Carney bills at $375 per hour. That comes out to $6.25 per minute. Or 0.104166 cents per second. Or 10.4166 cents per second. Mr. Leon W. Berg bills at $300 per hour. That comes out to $5 per minute. Or 0.08333 cents per second. Or 8.333 cents per second. Mr. Robert Wayne Lazaro bills at $300 per hour. That comes out to $5 per minute. Or 0.08333 cents per second. Or 8.333 cents per second. Mr. Matt Trudeau bills at $200 per hour. That comes out to $3.33 cents per minute. Or 0.05555 cents per second. Or 5.555 cents per second. Then there are the deputy sheriffs, paid $42,846.34 per minute. 0.00572 cents per second. The courtroom clerk is paid $38,040.30 per minute. 0.00508 cents per second. That's not everyone or everything, but close enough. Therefore, judge this Judith ENSOR's knowingly false and fraudulent.
He is the driving force behind this litigation.
Statement cost over 60 cents. There are countries where you can feed an entire family for that amount. Therefore, judge this Judith ENSOR's knowingly false and fraudulent.
The number of emails that people had to review.
Statement cost $1.02. There are countries where you can feed an entire family for an entire day for that amount. Therefore, judge this Judith ENSOR's knowingly false and fraudulent.
He is just papering like that.
Statement cost $1.25. There are countries where you can feed an entire family for an entire day, including dessert for that amount. Would you like to know how much it costs for an extremely high-level psychotic and mentally deranged, unconscionable person to knowingly, falsely and fraudulently state?
I don't know if it's this diagnosed mental illness.
$1.48. There are countries where you can feed part of an entire village for that amount. Now, we will go into super summary mode with Bradford G.Y. Carney and the rest coming, as you will see. Well, it's obvious what they all did with the information from day one. Then we will go to the finale and closing arguments by the Maryland State's Attorney, Scott D. Schellenberger, and his team. That will be 4 years later, and in 2015. January the 6th, 2011, Mr. Leon W. Berg, begins. January the 7th, 2011, Dr. Catherine Killeen begins. And needless to say, the constant chaos never stops. In fact, it constantly escalates. And Garrison Forest School asks that Maya not return.
Message from the state's attorney. Victims and witnesses in criminal cases deserve to have their voices heard.
So, who are the hackers? That's not a message. That's a joke.
They do deserve to be heard. Just not here in Covert County.
That's okay. You're up next. And get to finish this presentation.
That should be exciting. I can't wait.
Look, John. Even Alex and Maya helped, and remember me helping with the cameras and the wiring. Look. They are hidden. Until you open your eyes.
Of the almost $200,000 in legal bills, much is attributable to inappropriate actions on the part of Mr. Stengel.
Now, you never did specifically mention what the inappropriate actions were. However, the transcript on this very day shows you switch the order of events, making it appear it was Mr. Stengel that initiated everything, when in fact, you are well aware that was not the case. No more than it was when Miss Siliski initiated the entire stream of events by filing her first fraudulent protective order on November the 29th, 2010, and Mr. Stengel was forced to respond. Then Miss Siliski instantly went on a smear campaign involving their schools, teachers, and whoever else she could con and manipulate. Or are you referring to the times Mr. Stengel attempted to notify the many victims they were being systematically abused? The victims, and the very people that you accept paychecks to protect. Inappropriate actions, such as this very presentation, isn't that correct? Besides,
Dr. Colleen's testimony was quite clear that her fee was extraordinarily high because of the hundreds of emails that she had to listen to. Well, I mean, I think the court indicated that you read that testimony. That's why I was going.
I told you I have no memory of it. And I read it at the time. I read it, good Lord, I read it back before the May date that you all postponed.
Well, I represented to you as an officer of the court that she did say that on the witness stand. I was present. I heard her say those words. I heard her say that their fees would never, ever, ever be this high, but for all of the emails and the communications that she had constantly with Mr. Stengel.
Mr. Carney, thank you for your confession. Judge this Judith ENSOR. Thank you for your confession. Therefore, number 1. Extraordinarily high because of the hundreds of emails. 1a. Mr. Stengel sent Dr. Killeen only 84 emails. 1b. Mr. Carney's bills clearly reflect the several hundreds of emails. 1c. Mr. Berg confessed to, with full knowledge, yet still duplicative things to Dr. Killeen. Number 2. Emails are read, not listened to. Number 3. Enza confesses that email evidence was not put in front of her. Number 4. Testimony is not evidence. The actual emails would be the evidence. Reality 101. Number 5. Besides Enza confessing, she has. Add to that.
I read it back before the May date that you all postponed.
Therefore, with no memory of it, Enza had to read Dr. Killeen's testimony again. This time, after November the 30th, 2012, and after all, testimony and evidence was provided. This making Dr. Killeen's fraudulent testimony even more obvious. Just as obvious, Enza never read those emails, aka the evidence. She could not have read them. So, how exactly did Enza's memory come back to her? And Joe? Well, Joe never returned with that binder, or any binder, for that matter. Surprise! Number 6. And another key word is postponed. That would be the child custody / supervised visitation SCAMS, which never resumed, which Mr. Berg continually blocked, and, assisted by Enza, refusing to permit Dr. Killeen be cross-examined, stating she must hear from Dr. Killeen only. Really? Because her testimony says it all. And, for the cherry on top of this list of confessions.
She did say that on the witness stand. I was present. I heard her say those words. I heard her say that their fees would never, ever, ever be this high, but for all of the emails and the communications that she had constantly with Mr. Stengel.
Number 7. However, Dr. Killeen's bills do not even remotely reflect these knowingly false statements. 7a. Communications, plural, and constantly with Mr. Stengel. Number 8. And, as an officer of the court, who received copies of all of Dr. Killeen's bills, show the opposite. Communications, plural, were with Miss Siliski and Mr. Berg. Number 9. Besides, if we remove all of that, Dr. Killeen's emails came to only $4,100. Not $20,000, or $30,000, or $40,000, or nearly $50,000. Number 10. Add to that the couple of times Mr. Stengel called Dr. Killeen with a question or concern. Dr. Killeen refused to call back. And the reason her bills reflect 0 phone conversations with Mr. Stengel. Number 11. So, what was really going on?
Rule 18-101.2. Promoting confidence in the judiciary. ABA Rule 1.2, West's Annotated Code of Maryland. Maryland Rules. A. Promoting public confidence. A judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary. B. Avoiding perception of impropriety. A judge shall avoid conduct that would create in reasonable minds a perception of impropriety. Comment. 1. Public confidence in the judiciary is eroded by improper conduct and conduct that creates the appearance of impropriety. This principle applies to both the professional and personal conduct of a judge. 2. A judge should expect to be the subject of public scrutiny that might be viewed as burdensome if applied to other individuals and must accept the restrictions imposed by this code. 3. Conduct that compromises or appears to compromise the independence, integrity, and impartiality of a judge undermines public confidence in the judiciary. Because it is not practicable to list all such conduct, the rule is necessarily cast in general terms. 4. Judges should participate in activities that promote ethical conduct among judges and attorneys, support professionalism within the judiciary and the legal profession, and promote access to justice for all. 5. Actual improprieties include violations of law, court rules, and this code. The test for appearance of impropriety is whether the conduct would create in reasonable minds a perception that the judge's ability to carry out judicial responsibilities with competence, impartiality, and integrity is impaired.
Also on September the 18th, 2013, Judge Judith ENSOR, on page number 121, states,
I have a deputy here, not because I don't think I can take the parties. I have a deputy here, not because I don't think I can take the parties. take the parties.
Maybe the Commission and their Executive Director Carol A. Crawford can explain how this specific rule
2. A judge should expect to be the subject of public scrutiny that might be viewed as burdensome if applied to other individuals and must accept the restrictions imposed by this code.
applies with the fraudulent gag order, fraude, demanded by the administrative judge, This Kathleen G. Cox, on November 16, 2015, by immunizing this crime ring, and all its members, such as this member. Page number 7.
15. Unless all videos, emails, and website postings to YouTube, Google and all other internet websites are immediately taken down. Petitioner, her counsel, Leon W. Berg, Robert W. Lazaro, Judge Judith C. ENSOR.
Can you explain that? Well. Yes. No. Well, hold on then. Because there is more. There is always more. Did you notice that mole? Robert Wayne Lazaro officially joins his crime ring. Let's not lose sight of the petitioner and white woman with free passes for unlimited crimes, Ms. Susan Siliski. Then, using a very strong Velcro, we have her counsel, Bradford G. Wykani. With more Velcro, attached is Leon W. Berg. More Velcro please, as we have Dr. Catherine Killeen. It's starting to look like a crime ring convention. Don't you agree? Well, hold on. There is more. There is always more. After all, This Kathleen G. Cox is driving the immunizations, and it appears her brake lines were cut. Apparently, we will need a lot more Velcro, attaching an entire company, attorneys, and associates. Should we assume that includes Craig P. Ward? He was not involved in the divorce in any way. However, his sworn filing was, well, fraudulent, as the dates did not line up. I guess they must add him. Can he at least bring his own Velcro? Okay, so what do we have so far?
15. Unless all videos, emails, and website postings to YouTube, Google and all other internet websites are immediately taken down. Petitioner, her counsel, Leon W. Berg, Robert W. Lazaro, Judge Judith C. ENSOR, Dr. Kathleen Killeen, the partners and associate attorneys of Royston, Mueller, McLean and Reed, LLP.
Carol A. Crawford, Executive Director, we need your undivided attention. You may recall, during National Quashing Day, November 26, 2012, Bradford G. Wykani represented Boys Latin School, the police, and sheriff's departments. Authorized by This Judith C. ENSOR. What might be the Commission's rule on This Kathleen G. Cox, authorizing Bradford G. Wykani, represent this group?
And all members of the Baltimore County Circuit Court bench.
Say it again.
And all members of the Baltimore County Circuit Court bench.
Take your time. Think about it. Sleep on it, if need be. While pondering that, don't you agree, that makes every judge in that circuit court building an adversary to Mr. Stengel? And if so, how then could any one of them preside over anything related to Mr. Stengel? While pondering that, as well, let's read the rest and the real issue at hand. But, before we do, these few minutes are from the presentation, Confessions of a Circuit Court Judge, This Kathleen G. Cox, abusing Jewish and other communities throughout the United States. 6 hours, 34 minutes of dissected frauds and abuses. A marvelous display of criminal acts, such as this very illegal fraudulent order. Frauder. This Kathleen G. Cox, twice having Mr. Stengel arrested. And, there is even a holiday gift card, from This Kathleen G. Cox, to Ms. Susan Siliski. The timeline order makes it easy to follow, putting everyone in the front seat of evil psychosis. Okay, let's finish this page.
And all members of the Baltimore County Circuit Court bench will continue to be unfairly exposed to public ridicule, and will continue to suffer incalculable reputational damage as a result of the offensive, outrageous, contumacious, and contemptuous conduct of respondent. 5 prior orders have done nothing to dissuade respondent from continuing his quest to publicly humiliate and embarrass anyone involved in his divorce proceeding, other than his first and last lawyers. Respondent continues to post likenesses of his children and the petitioner, and in his own words, will never stop. Wherefore, petitioner respectfully requests that, a. This court pass an order finding respondent in contempt of court. b. That this court pass an order incarcerating respondent for his wholesale disregard of this court's 5 prior orders.
Note, apparently crime pays, but doesn't look so good. Dear Carol A. Crawford, we have hundreds of these, which you were provided. So, here is one more, for now. Dear Carol A. Crawford, or any big shot on this page. Can you explain this?
She's apparently not in the Bird School of Ethics. Bird School of Ethics. Bird School of Ethics.
West's Annotated Code of Maryland. Maryland Rules. Title 18. Judges and Judicial Appointees. Chapter 100. Maryland Code of Judicial Conduct. Rules governing extrajudicial activity. Rule 18-103.3. Testifying as a character witness. A. Rule 3.3. Except when duly subpoenaed, a judge shall not testify as a character witness in a judicial, administrative, or other adjudicatory proceeding or otherwise vouch for the character of a person in a legal proceeding. Comment 1. A judge who, without being subpoenaed, testifies as a character witness, abuses the prestige of judicial office to advance the interests of another.
I find that of the almost $200,000 in legal bills, much is attributable to inappropriate actions on the part of Mr. Stengel.
I'm just a gatherer of information.
I find that of the almost $200,000 in legal bills, much is attributable to inappropriate actions on the part of Mr. Stengel.
I'm just a gatherer of information.
Besides what was already mentioned, where you switched the order of events, let's provide an actual occurrence, which you claimed as Mr. Stengel's wrongdoing, therefore driving the litigation, and what you consider inappropriate actions by Mr. Stengel. Inappropriate actions, which you stated caused $200,000 of legal bills, but really, the numbers are well over $500,000. And if the others are included, as they should be, such as the abused schools, the abuse organization, religious institutions, and what appears to be the rest of the never-ending list, then include the taxpayers, it's in the millions, plural, which just so happens to be related to your very allegation of Mr. Stengel's wrongdoing. However, we already learned, you all use what Mr. Stengel refers to as extremes. Ironically, your allegation is on the very page where we began. Page number 193.
Invoice number 45943, dated September 7th of 2011, contains an entry for watching the Truth About Susie video. There should be no video. No one should be watching a video. There should be no video. No one should be watching a video. There should be no video. No one should be watching a video.
As Mr. Stengel clarified earlier, you and the other extremely high-level unconscionables, number one fear, bar none, is reality. Video is reality. Nobody should be watching any reality, especially months of reality taken in the home prior to your crime rings fraud scams. And the very reason your $200,000 speech is way below reality. Besides, the hundreds of clips of obvious psychotic, violent, and constant abusive action shown on the videos, otherwise known as reality. Then there are the months of videos constantly showing Mr. Stengel trying to protect Alex Meyer, which is also apparently very bad. Then, there is the federal computer hacking crime, alone should have landed Miss Silisky in prison for up to 5 years, for one incident, but there were more. Therefore, almost all, if not all, of the legal bills were directly related to your own allegation, directed towards Mr. Stengel. But, as we know, allegations equals confessions. Then what would have come of your crime rings fraud, extortion and racketeering, to name just a few? Then, there is something the psychology field itself is well aware of, and that is, your types are not happy unless you are manipulating or conning someone or something. In other words, you get joy out of the misery you bring to others. FYI, ignoring the federal computer hacking crime by itself is a crime. And to this day, everyone refuses to provide the hackers information. Besides, you all would have missed out on all the fraud, extortion and racketeering, to name just a few. Just look at all the joy you all would have missed out on, with the misery you all brought to so many. Conning and manipulating the schools, the many teachers, and their staff. Hoodwinking, and abusing an abuse organization. Then the joy from the children, parents, and religious leaders was surely thrilling for you all. Or the police, and the many police departments. Teetering with the US postal agents, and even the FBI, has to be at the top of your thrill meter. And let's not forget the deputy sheriffs that you look at each day, with such ease. How thrilling was, and is it, to con and manipulate doctors, lawyers, and let's not forget other judges. The excitement you all must have felt, toying with well over a dozen in the psychology field, including psychologists themselves. How great is that? How thrilling was using people's names without their knowledge, or a school, or whoever else's identity was stolen as needed. But surely, your psychotic crime ring's crowning achievement had to be, by far, conning and manipulating people, a synagogue, and even a private school, to surrender their own rights. Wow! Something to tell the grandchildren about. Where on the thrill meter of the removing of freedoms rise to, when spitting on the graves of veterans who gave their lives to protect and preserve those very freedoms?
Article 40. Freedom of speech and press. West's Annotated Code of Maryland. Constitution of Maryland adopted by Convention of 1867. Maryland Constitution, Declaration of Rights, Article 40. That the liberty of the press ought to be inviolably preserved, that every citizen of the state ought to be allowed to speak, write and publish his sentiments on all subjects, being responsible for the abuse of that privilege.
How detrimental are Mr. Stengel's presentations? On November 16, 2015, a circuit court judge judged this Kathleen G. Cox at what was to be the initiation of the illegal removal of Mr. Stengel's First Amendment rights. Was summed up on that very day with this judge's one question.
How is it that you knew to be present here today?
Say it again.
How is it that you knew to be present here today?
You do not want to miss confessions of a circuit court judge abusing Jewish and other communities throughout the United States, complete with loads of dissecting. Before we go to the finale, just a couple examples from the Get Bobby presentations which they were provided, including the state's attorney, as it's clear this is not Miss Zaleski's first rodeo. And you will see Uncle Ray, the appellate judge, as well.
But the piece that I remember the most as a little girl, as the little sister, was that he was the most protective person I've ever known. And I feel I am constantly saying to my son, you must take care of your sister. You must. It is your birthright. He did that.
The one presentation, Get Bobby, also provided to the state of Maryland, is 41 pages, and is more than shocking. Bobby was always the protector. Sally was never afraid of her son. However, who she always was, and is afraid of, is her psychotic daughter. How not afraid of Bobby was Sally? Well, they had to write a letter to the judge, for Sally. Then Miss Zaleski edits parts of that letter. And Sally's friend's words, describing Sally's actions, speak volumes. We will only provide very small bits of this. It will not only be clear, but familiar. Peggy St. G. writes,
I've been agonizing over Sally's waffling. So I wrote a statement.
We will do this very quick. Here is the detached statement. As you can see, it's quite long. Miss Zaleski responds. From Susie. However, she writes it as if it's coming from Mr. Stengel. No kidding. Making it look like Mr. Stengel supports all this garbage. Except, in her excitement of the identity theft, she sends it from her own email address.
Hi, Sally. So I added the, or comes over, banging on my door and ringing my doorbell. Also below you will notice I added, uninvited, and unexpected. I think the unexpected, in the middle of the night, is key. Signed. Mark.
Huh? Surely, Alison Meister Friedman, and the staged Halloween scam, will like the uninvited part. Sound familiar? Sound familiar? Besides, it's the key. Goals and agendas. Then she writes,
You can also see what I added at the bottom. I think it creates a picture that can only help. If not, take it out.
Translated. It's all bullshit, but if it helps. How did this all begin? With the temporary order. Let's have the posse explain it. From Peggy St. G. Note, protective order. Already wrote a paper for Sally, to repeat. Do not forget. Do not forget. This is all driven by Susan Zaleski. And every nickel that Sally gave to her son was a nickel less inheritance for Susan. Got it? Good. And the paperwork the judge looked at was not Sally's, but from Susan and her posse. Peggy writes,
Sally and I went to district court today to file for a protective order. Then she was heard by a judge, who looked at her paperwork and basically said the same thing. He asked if Sally was afraid that some harm might come to her if she didn't get this protective order. He asked this question in every way he could, to lead her to say that she was afraid. She waffled. Finally, he asked her again, and I told her she has to say yes, so she whispered yes.
They fraudulently obtain the temporary order, then have it extended for a year. Then, it's get Bobby again. Of course, in the name of helping him. Here is a final, for this presentation, and quick email string. And, let's not forget, all of this history, and much more, was also provided, early on, to Mr. Berg, Dr. Killeen, Mr. Carney, Mr. Lazaro, Judge Judith ENSOR, the state of Maryland, and many others. Showing the history, and this is what Miss Siliski does. This email sent from Fred Schatzman, Janet Schatzman's husband, to Ms. Susan Siliski, Sally Siliski, and 3 of Sally's friends. Part of the posse. Otherwise known as victims, being used in a smear campaign. This email is very, very long. And sounds like Susan talking. Miss Siliski then forwards that email to Mr. Stengel, and states,
Well said.
Mr. Stengel replies to Miss Siliski, and states, Here is my theory. Bobby is and always will be Bobby. Whatever he has been doing for the last 40+ years, works for him, and it will work for many years to come. It's all of you that need the help. And Mr. Stengel can do this. Besides, what's the difference whether Mr. Stengel has money or not? If he has $50 million, he is still not responsible for your crime ring's designed fraud from day one. You steal his children, feed them to a medically documented mentally ill, violent, crazy nut job, rape them of their childhoods, knowingly con and involve their schools, and entire communities, in your frauds, and Mr. Stengel should pay. Really. When Alex said and documented in his audio journals, often being beaten up, and he wanted to live with his father 100% of the time, and Maya with her mother, only every other weekend. Yet not one mentioned by Mr. Berg or Dr. Killeen. Known as white-collar child trafficking. Mr. Berg and Dr. Killeen, even obstructing justice, by manipulating Boyce Latin School of Maryland to not report Alex's reported abuses to his school, to the authorities. Twice. Let's listen to Mr. Stengel explain it to the like personality person you handed all of this fraud off to, after you were warned, by the Commission on Judicial Disabilities, directly related to Mr. Stengel's cases, and recused from Mr. Stengel's cases. Someone you were sure would not report your actions. Someone that will also keep this fraud case specially assigned. Translated, alienated. Surely the Commission would not allow any judge to call someone a liar without evidence. Would they? Otherwise, actions like that would still be considered honorable. In which case, the Commission's rules are in place to protect the corrupt judges, not the public. And for the finale. Closing arguments. We will add one more piece to this presentation. Mr. Stengel was falsely and fraudulently incarcerated for reporting this crime ring's crimes. That was the second time Mr. Stengel was falsely criminally charged by the state of Maryland and the state's attorney, Scott D. Schellenberger. The first time, the main allegation was not even possible. Ms. Susan Siliski, from Siliski and Company, and A&M Marketing, had not received anything from Mr. Stengel. Not one thing. Yet, Ms. Siliski attempted to file charges with the commissioner, and was rejected. Hana, a Jewish women's abuse organization, being abused themselves by Ms. Siliski for years, was again conned, yet rejected from the city of Baltimore. Ms. Siliski then dragged Hana to Old Faithful, Scott D. Schellenberger, who happily brought criminal charges against Mr. Stengel. Mr. Stengel was arrested and incarcerated. Hana filed a harassment charge, which contained 90 days prison time. Ms. Siliski also filed a harassment charge for 90 days, and a charge of stalking, which penalty was 5 years. Ms. Siliski had not received anything whatsoever from Mr. Stengel. Furthermore, Mr. Stengel was not even in the state of Maryland, let alone stalking anyone. Information they themselves verified. Mr. Stengel was incarcerated with $1.5 million bail. More than most murderers. There was an initial list provided to the state by Ms. Siliski, alleging these people, over 140, did not want to be contacted by Mr. Stengel. This list was also used as evidence to falsely incarcerate Mr. Stengel. Mr. Stengel, after being released, was on house arrest with an ankle monitor for several months. As always, Mr. Leon W. Berg and Bradford G. Carney were fully involved in these criminal acts as well. In fact, Mr. Berg was trying to have Mr. Stengel federally charged and sent to a federal prison for what was reporting his crimes and abuses to so many. The first list contained names, some unknown how many were used without their knowledge or consent, and as one person said, surely was not told what it was being used for. Another said, they knew nothing about this list, nor were they asked to be on any list. Further stated, they did not even speak with Miss Silisky. This is called identity theft and identity fraud. A second list, which was used to further this fraud and abuse, and imprison Mr. Stengel for up to 5.5 years, was provided to Mr. Stengel by the state of Maryland. Now the state of Maryland charges each clearly state
having fully investigated said case.
This signed by Scott D. Schellenberger, State's Attorney, and Jill P. Savage, Assistant State's Attorney, who herself told two people Miss Silisky was not a credible person, yet maintained these criminal charges, keeping Mr. Stengel in prison, then under house arrest. Mr. Stengel had to report weekly to the jail to provide a urine sample, although nothing ever mentioned about drugs. However, it was their protocol. He also had to pay $75 each week, which he did not have to spare, and sometimes ate mustard sandwiches, as he was determined to see justice for his children, and free them from these psychotic games played by this crime ring, and the psychotic Susan Silisky. This costing Mr. Stengel great grief, despair, and much more, enduring cruel and unusual punishment, just to name a few. Also tens of thousands of dollars. Mr. Stengel, also well documented, told this crime ring, they will need to kill this father to win this war. And told them all, you can't steal my kids, and they are not for sale. The level and depth of evil that exits from each and every pore in their tar-filled bodies, of all those involved, can be seen by two witnesses, forwarded by Miss Silisky, and accepted by the state of Maryland, Scott D. Schellenberger, and Jill P. Savage. Witnesses, to be used against Mr. Stengel, to falsely incarcerate him for 5.5 years. They are
Witnesses. 1. Alexander Stengel. 2. Maya Stengel.
One more time.
1. Alexander Stengel. 2. Maya Stengel.
It's August 26th at 9 a.m. and if anyone hears this, I just want to stay with my dad. By that I mean like full custody with my dad.
Now the state of Maryland, Scott D. Schellenberger, Jill P. Savage, and the rest of this crime ring are all involved, and collectively so, in identity theft and identity fraud, among many other criminal acts, such as the abuse to minor children, as just witnessed. Although the charges each clearly state having fully investigated said case. This signed by Scott D. Schellenberger, State's Attorney, and Jill P. Savage, Assistant State's Attorney, is false and fraudulent and clearly perjurious. After speaking to some, and shown both the first and second list, were unaware of such a list. The second list, provided by the state, clearly states at the bottom,
any contact with anyone on the above list may also be grounds for harassment charges, as these individuals and entities do not wish for the defendant to have any contact with them. The parties on the list wish for the prohibition on contact to be permanent, unless the defendant is notified otherwise.
Mr. Stengel was told they knew nothing about this list, or any list, and further stated they did not speak to Miss Silisky, or anyone from the state's attorney's office, and were extremely upset their name was being used without their knowledge or consent. Even more so, their name being used to cause harm to Mr. Stengel, his children, or anyone for that matter. Therefore, just in that instance, the
having fully investigated said case
is an outright lie. Fraudulent actions by the state of Maryland, the state's attorney, Scott D. Schellenberger, and Assistant State's Attorney, Jill P. Savage, where they themselves are committing crimes, and forwarding crimes, of this very crime ring. The question remains, how many more of these identity theft and identity fraud victims are there? Also disturbing is the paragraph below, where it states,
the defendant agrees not to post, publish, email or disseminate in any way any information, photographs, or videos, whether disparaging or otherwise, about his ex-wife, Susan Silisky, A.K. Susan Stengel, or his children, Alex and Maya Stengel. This would include the details of their divorce, videos taken prior to their divorce, emails or other documents exchanged prior to their divorce, and after their divorce, and any documentation that was related to their divorce hearing, or subsequent hearings. Jill Savage, Assistant State's Attorney, for Baltimore County.
That paragraph is more in line with an attorney representing Miss Siliski in her divorce case, and in further alienating the truths and crimes by Miss Siliski and this crime ring than it does coming from the state of Maryland, as it is nearly identical to all their previous court orders. But really, court frauders. The state of Maryland is now acting representative for this crime ring, especially given we know there are names being used illegally without their knowledge or consent to cause harm, thereby attempting to use this fraudulent action to prevent those on this very list from ever knowing their names were illegally used and being used to cause harm, even to themselves, as their good names are being tarnished to the detriment of children, schools, the public, and themselves. The same actions taken to illegally remove Mr. Stengel's First Amendment rights without due process or even invited to defend those rights. The state of Maryland being used as a personal tool to assist known criminals. Their goal: stop Mr. Stengel from informing their victims they have and are still being victimized by this ever-growing crime ring, which from the looks of it appears to include Scott D. Schellenberger and Jill P. Savage. Don't get misdirected by thinking the state of Maryland is assisting in some divorce case. The divorce case itself is not about a divorce case. If it was, it would have ended within days after seeing 5 or 6 video clips of the hundreds taken from inside the home. Surely after a federal crime is caught on tape. The cameras were placed there months prior to protect his children. The over 5 years and still going proceedings were never about a divorce case. This is no more about a divorce case now than it was when it began, back in November 2010.
I'll tell you what, I'll give you the cameras when you give me my hard drive off the servers.
Now, we get to an even more curious part. Which organizations are being used without their knowledge? What reputations are being tarnished by this abuse, whereby having an innocent man falsely incarcerated? What are Ms. Susan Siliski, Bradford G. Y. Carney, Leon W. Berg, Dr. Catherine Killeen, Robert Wayne Lazaro, Judge this Judith ENSOR, Judge this Kathleen G. Cox, the State of Maryland, Scott D. Schellenberger, Jill P. Savage, Glenn Grossman, along with the Attorney Grievance Commission of Maryland, retired appellate Judge Raymond Teamley, and others, all protecting by using extreme measures, such as illegal gag orders, false incarceration, illegally removing the First Amendment rights of a United States citizen, simply to prevent Mr. Stengel from informing victims they are in fact being used, either without their knowledge, or with the knowingly false and fraudulent supplied information, to obtain their agenda. The many illegal actions taken over the years, and obvious attempts continued by the state of Maryland, to remove Mr. Stengel's First Amendment rights to free speech, also violates the rights of the many victims to be informed. Many agendas, which includes using these names in order to more easily manipulate and con others, to assist in their criminal activities, and cause more harm, with foreknowledge and malice, all waged against minor children, schools, teachers, doctors, lawyers, psychologists, a Jewish women's abuse organization, religious leaders, mothers and fathers, brothers and sisters, aunts, uncles and cousins, judges, the police and sheriff's departments, citizens in multiple states, as well as in other countries, the U.S. postal agents, even the FBI, just to name a few. Given what we have learned thus far, it seems extremely strange to see many on this list. Especially one in particular. Garrison Forest School, faculty and professional staff. What say you, Governor Larry Hogan? Well, dear Governor Larry Hogan, which team are you playing for? Team Predators? Team Sponsors? Or Team Victims? Well,
were you seen in a photo with Ms. Susan Siliski?
As we piece this fraud puzzle together, we know Garrison Forest School was wrongfully involved in the first place, then infiltrated by this group. What did those very people abusing Garrison Forest School, its teachers and staff know, and have known all along? The very reason Miss Sileski filed that first fraudulent protective order, which began all the abuses that ensued. Curiously, it relates to the very reason the state of Maryland surrendered their bogus criminal case, yet refused to tell the hundreds of victims the true reason. That original protective order was illegally obtained, in order to get Mr. Stengel out of the house. Let's listen to Miss Sileski herself tell everyone why so many were used and abused for so long. Just 2 days before that initial protective order, on November the 29th, 2010.
I'll tell you what. I'll give you the cameras when you give me my hard drive off the servers. I'll tell you what. I'll give you the cameras when you give me my hard drive off the servers. I'll tell you what. I'll give you the cameras when you give me my hard drive off the servers. I'll tell you what. I'll give you the cameras when you give me my hard drive off the servers.
After Mr. Stengel was evicted by 2 sheriffs from his own home, on November the 29th, 2010, comes this.
Now, you're not in trouble for getting into his account, are you? Because I had to crack his password for you to do this. Find Mark 7 on whatever computer is Mark 7.
I think Mark 7 is his laptop, which he has with him.
And he's got it.
But he's got to have backups on stuff, right?
Right, that's what I'm assuming is on these drives here, and also that window.
I'll tell you what. I'll give you the cameras when you give me my hard drive off the servers.
Now, you're not in trouble for getting into his account, are you? Because I had to crack his password for you to do this.
I'll tell you what. I'll give you the cameras when you give me my hard drive off the servers.
The state of Maryland was provided many of those crimes years earlier and did nothing. However, apparently, over a year later, and on January the 18th, 2012, and under the Maryland rule of allegations equals confessions, Old Faithful, Scott D. Schellenberger, accepts criminal charges, which are not even possible. And when Mr. Stengel then brought lots of evidence, confirming Miss Sileski's criminal filing were lies to the state, and fraudulent. The state did nothing. It appears to have something to do with Miss Sileski's skin color. Accepting criminal charges that are bogus and fraudulent. No problem. Any action taken on the 37 perjurious statements and provided to the state with evidence of each one? Hell no.
We will teach your children by example.
For now, we have the state of Maryland, Scott D. Schellenberger, and looking to add the many others responsible, such as Jill P. Savage. Dear state of Maryland, and Scott D. Schellenberger, who, specifically, fully investigated Garrison Forest School, their faculty, and professional staff. Well, what began with lies and deceit, and a crime-ridden hard drive, then using the legal system as a tool to forward yet more crimes, turned into the abuses to all in their paths. What do all of these people have in common? What is it that has the state of Maryland's top prosecutor committing crimes, covering up crimes, and jail the reporter of crimes? Why would the state of Maryland have the need to lie, to keep victims in check? What would have the state of Maryland acting as the criminal and victimizing its own citizens? What would have the state of Maryland falsely use the identities of people, a school, and surely many others, then do everything to alienate those very victims by committing more crimes? What would have the state of Maryland's top prosecutor and assistant state's attorney using the state's coffers, therefore the taxpayers' money, for personal interests and gain? What gives them the right, and who the hell do they think they are, to use taxpayer dollars to abuse those very taxpayers? And where is Larry Hogan, who governs this white-collar child trafficking state? Mr. Stengel outright rejected the state's offer, which contained Garrison Forest School's name, then provided a 148-page package from Mr. Richard Karseski, containing just a few samples of Miss Sileski's long history of criminal activity, consisting of local, state, and federal crimes. The state surrendered, yet never brought any charges against Miss Sileski. However, Jill P. Savage in court and on the record fabricated yet another story opposed to the truth, such as Miss Silisky is a career criminal as the reason they surrendered. Instead, in an effort to keep all of their victims, and there are hundreds, in check, stated this.
I think that we're going to be deficient in proving harassment charges because we were not able to notify Mr. Stengel that the people that were receiving these mailings didn't want the mailings. But since that time, HANA, the Jewish Advocacy Domestic Violence Group, has gotten involved, and 92 parties have reached out to them to say that they don't want contact with Mr. Stengel.
This 24-second statement, made on the record, is dissected in the confessions of a circuit court judge. Judge this Kathleen G. Cox. That 24 seconds is so flawed, in so many ways, it's incredible. Besides, Miss Silisky curiously disappeared out of the picture, apparently due to the real reason the state surrendered. We have HANA, the Jewish Women's Abuse Organization, themselves, having been abused since 2010. And in recent years, by the state of Maryland, is now thrown under the wheels of this bus, which quite frankly, is on fire, and has been, since November the 29th, 2010. We focus on the obvious one, glaring, with bright lights flashing. Jill Savage states whatever she states, which is false. Regardless, it took the state a year to figure out what was an initial action. Really? Spewing nonsense, as if Jill Savage just graduated from prosecutorial preschool. Who is buying this? Brooklyn Bridge? Let's listen to the beginning part again.
I think that we're going to be deficient in proving harassment charges because we were not able to notify Mr. Stengel that the people that were receiving these mailings didn't want the mailings.
That's the best the state of Maryland could come up with? Really? If so, this will be real quick. Dear Ms. Jill Savage, however, your fraudulent criminal charges clearly states,
after, a request to desist.
I believe the key word there is, after. Now after a year, you are saying that was a lie? This is what the hundreds of victims, at the hands and psychosis of Ms. Susan Silisky, Bradford G. Y. Carney, Leon W. Berg, Dr. Catherine Killeen, Robert Wayne Lazaro, Judge this Judith ENSOR, Judge this Kathleen G. Cox, the State of Maryland, Scott D. Schellenberger, Jill P. Savage, the Attorney Grievance Commission of Maryland, the Commission on Judicial Disabilities, and the other predators and predator-friendly group are supposed to buy, hook, line and sinker? That's what you are selling to all your victims? Even the ones so deluded, where the depths of systematic psychological warfare, waged upon them, by so many in this psychotic crime ring, and for years, had them removed their own First Amendment rights, and some had their minor children sign away their rights, as well. And how much did it cost the taxpayers? It does not even require a response. Good luck. Maryland.
I think that we're going to be deficient in proving harassment charges because we were not able to notify Mr. Stengel that the people that were receiving these mailings didn't want the mailings.
Given the state's first fraudulent criminal filing and first fraudulent criminal charges, there appears to be many patterns. One being
after, warning to desist, rinse, and repeat.
After, warning to desist, rinse, and repeat.
Surprise!
I think that we're going to be deficient in proving harassment charges because we were not able to notify Mr. Stengel that the people that were receiving these mailings didn't want the mailings.
As you so kindly put on the record, further confirms the state of Maryland, Scott D. Schellenberger, Jill P. Savage, and all the others involved, were clearly involved in the violations of Mr. Stengel's rights. Also, you all individually and collectively did so, with foreknowledge and malice, to cause as much harm as possible. Because
West's Annotated Code of Maryland. Criminal Law. Title 3. Other Crimes Against the Person. Subtitle 8. Stalking and Harassment. Harassment. Prohibited. A person may not follow another, in or about a public place, or maliciously engage in a course of conduct that alarms, or seriously annoys the other. 1. With the intent to harass, alarm, or annoy the other. 2. After receiving a reasonable warning, or request to stop, by or on behalf of, the other. And 3. Without a legal purpose. Exception. B. This section does not apply to a peaceable activity intended to express a political view or provide information to others. Penalty. Imprisonment not exceeding 90 days.
Therefore,
Article 24. Due process. West's Annotated Code of Maryland Constitution of Maryland adopted by Convention of 1867. Maryland Constitution, Declaration of Rights, Article 24. That no man ought to be taken or imprisoned or disseized of his freehold, liberties or privileges, or outlawed, or exiled, or, in any manner, destroyed, or deprived of his life, liberty or property, but by the judgment of his peers, or by the law of the land.
And Mr. Stengel can do this.
West's Annotated Code of Maryland. Criminal Law. Title 3. Other Crimes Against the Person. Subtitle 7. Extortion and Other Threats. Extortion by state or local government officer or employee. Political subdivision defined. A. In this section, political subdivision includes a 1. County. 2. Municipal corporation. 3. By county or multi-county agency. 4. County Board of Education. 5. Public authority. Or 6. Special taxing district. Prohibited. B. An officer or employee of the state or of a political subdivision may not wrongfully obtain or attempt to obtain money, property, or anything of value from a person with the person's consent, if the consent is obtained under color or pretense of office, under color of official right, or by wrongful use of actual or threatened force or violence. Penalty property value of $500 or more. C. If the value of the property is at least $1,000 but less than $10,000, a person who violates this section 1. Is guilty of the felony of extortion and on conviction is subject to imprisonment not exceeding 10 years or a fine not exceeding $10,000 or both. And 2. Notwithstanding any pardon, shall be barred permanently from employment by the state or by a political subdivision. Penalty property value of more than $10,000 but less than $100,000. D. If the value of the property is at least $10,000 but less than $100,000, a person who violates this section 1. Is guilty of the felony of extortion and on conviction is subject to imprisonment not exceeding 15 years or a fine not exceeding $15,000 or both. And 2. Notwithstanding any pardon, shall be barred permanently from employment by the state or by a political subdivision. Penalty property value of $100,000 or more. E. If the value of the property is $100,000 or more, a person who violates this section 1. Is guilty of the felony of extortion and on conviction is subject to imprisonment not exceeding 25 years or a fine not exceeding $25,000 or both. And 2. Notwithstanding any pardon, shall be barred permanently from employment by the state or by a political subdivision. Penalty property value of less than $1,000. F. If the value of the property is less than $1,000, a person who violates this section is guilty of the misdemeanor of extortion and on conviction is subject to imprisonment not exceeding 18 months or a fine not exceeding $500 or both. Limitations. G. A prosecution for a felony under this section shall be instituted within 5 years after the crime was committed.
Jill P. Savage made no mention regarding the stalking charge. What happened to that? Why not even a mention? Miss Susan Siliski is the state of Maryland's star witness. Yet, Miss Siliski magically faded away.
This is one of those tricky things.
Does that really say dignity of the state? You can't be serious.
This is one of those tricky things.
The alienation game. The alienation game. Dear Larry, what you will now witness are active crimes taking place. Fraudulent liens on Mr. Stengel and his children's family home by the criminals who with the rest of their crime ring spit in the faces of all those that served in the armed forces and stomp on the graves of the many that gave their lives. Criminals sponsored by the state of Maryland, paid for by the taxpayers of Maryland, and apparently authorized by you, who governs it all. And now they are trying to pass their frauds through a federal court, as the criminals' deception is not limited to only local and state venues. Hell no. Have a look at some of your dirty laundry. Mr. Leon W. Berg, illegally obtained lien. Just another crime. Dr. Catherine Killeen, illegally obtained lien. Just another crime. Miss Susan Siliski, illegally obtained lien. Just another crime. Miss Susan Siliski, illegally obtained lien. just another crime. Ms. Susan Siliski, illegally obtained lien, just another crime. Ms. Susan Siliski, illegally obtained lien, just another crime.
West's Annotated Code of Maryland. Criminal Law. Title 3. Other Crimes Against the Person. Subtitle 8. Stalking and Harassment. False, fictitious, or fraudulent liens or encumbrances prohibited. In general. A person may not file a lien or an encumbrance, in a public or private record, against the real or personal property of another, if the person knows that the lien or encumbrance is 1. False. Or 2. Contains, or is based on a materially false, fictitious, or fraudulent statement, or representation. Violations and penalties. B. A person who violates this section, is guilty of a misdemeanor and on conviction is subject to 1. For a first violation, imprisonment not exceeding 1 year, or a fine not exceeding $10,000 or both. And 2. For each subsequent violation, imprisonment not exceeding 5 years, or a fine not exceeding $10,000 or both.
But alone would be up to 16 years for Miss Siliski, and up to $40,000 in fines. This is only up to a year for Mr. Leon W. Berg and Dr. Catherine Killeen, and up to $10,000 in fines for each. That doesn't begin to pay the taxpayers back. However, with all their other counts of criminal activity, if they lived to be 300 years old, that would still not come close to their individual, accumulated prison time. Not even close. Then, if we add the rest of this crime ring, gang, the numbers when released, will be shocking, even to the hardest of criminals. Keep in mind, this entire presentation is much less than 2% of why these criminals are trapped. Fraud upon the court. Rather, frauds, plural, upon the courts, plural. And now, trapped within their own fraud, upon the federal court. And
millions of taxpayer dollars. Many millions. And, still going. Many millions. And, still going.
Anyone above the line want to help the victims? Otherwise, they're your victims. Have you noticed? They are all in uncharted waters, and have been for years. Have you figured out you're watching a reality show where you can participate? Ask the research subjects questions and watch how 2 + 2 never equals 4.
What do whites have to do to be properly charged with serious crimes in Maryland?
White-collar child trafficking.
Get the kids' passports.
Get the kids' passports. Larry, Alex's was obtained illegally. False statement to that federal agency.
Yes. Is or knows. It was confessed to her. Apparently, it's just another federal crime.
Go team, go!
With such ease, illegally removing many freedoms, such as the freedom of speech, the freedom to be informed, the freedom to know the truth, and the freedom for justice, so not to be enslaved. And the very reason so many heroes fought and gave their lives to defend and protect. Yet, these cowards have no problem demanding the hundreds of their victims remain on the front line, shielding their masters' criminal activities, so deluded they do so voluntarily, although unknowingly stripped of their freedoms to accept information and to be informed of truth. Yet when asked to do the same thing, they all, just as this coward demonstrates, not only refusing to adhere to what they demand of their victims, but refuses to even respond. We now wait and see which ones will expose themselves in favor of abuse and oppression, surely to look each one eye to eye, as each are questioned by Mr. Stengel before their adversaries.
It's about how people were manipulated and conned against myself and my children. Okay? And to this day, they still don't know. So these people want to leave these people, and there are hundreds of them, in a state of delusion That's their attempt, to leave them in a state. Don't let the victims know, by the way, that they've been victimized by these people. And we're going to sign an order that you can't tell the victims that they're victims. Okay? And instead we're gonna brainwash them, and we're gonna make them deluded, where they send me a letter threatening me criminal prosecution should I contact them. Now I have one question for Your Honor. What would it take for you to sign anything to give away your own First Amendment right to receive information?
Then, after illegally removing the rights of all voters to be informed, Judge this Kathleen G. Cox, months later, is re-elected to the bench. And, for 15 years. Surely, had the voters been permitted to be informed, would have voted for this thug, correct? Hell no. Elected by fraud. Elected by fraud. Elected by fraud.
Explain it to this group.
Your victims have many questions for all of you. What really happened to Gordon Meyer Silisky? Who killed Bobby Silisky? See Anne Arundel County Orphans Court records. Follow the money. And
I'll tell you what.
By the way,
I'll give you the cameras when you give me my hard drive off the servers.